Move on unlisted regular bail lordship today if time permits lordship. 379
Yeah,
lordship.
sure, time will permit, but what is the matter?
Lordship 379 lordship did not recovered from this petitioner lordship.
How many days?
Lordship already lordship co-accused released on bail by the court below lordship.
What
5
is-
days lordship.
What is the stolen material item?
That was not lordship. I am a lordship enterprise. I have an enterprise lordship. Some say lordship he earlier doing such business. Earlier.
Yes.
May I take it?
Yes.
For listing, my lord.
When?
28.
What is the matter? This motion?
Stage is on motion.
I'm praying for Monday, my lord.
Motion?
Motion, my lord.
Motion related to these bans are allowed date to me military.
Same prayer lordships.
Allowed, all allowed. Motion or allowed?
It's a criminal petition, my lord, on 28.
Motion?
Yes, my lord. Yes.
All motion or allowed? Whatsoever.
Maybe
But it must relate to these bans.
I beg to mention item number 59.
Item number
59.
59.
Lordship, I may withdrawn with liberty to file a fresh. Yes, my lord.
Coupling,
সেদিন
Huh?
না থাকিব বেলে দিন সেদিন না থাকিব
53.
59 মানে
59. Okay. Want to withdraw with a liberty. Yes, next case.
Yes, my lord.
Lordship. Lordship, I beg to mention item number 45 for
55.
adjournment.
Huh?
For adjournment, your lordship, because my senior certainly got serious illness.
order
Okay.
Much obliged.
Have you informed the 43? Huh?
45
45. Okay.
Wait, please, your lordship. Lordship, I beg to mention item 23.
Item 23.
Yes, lordship. Lordship, in this matter, the petitioner has engaged us as a new set of counsel, lordship. Yes.
Uh-huh.
The petitioner has engaged us as a new set of counsel, lordship. Yesterday only we were formally informed, lordship. Today we'll be filing our Bakalat number. That is why I pray for 1 week time.
Adjournment. When do you want?
1 week, lordship.
1 week.
Like,
Give a date after. Yes.
May I please, I beg to mention item number 55, supplementary list, your lordship.
Hmm.
And your lordship, item number 61, bail hearing.
Hmm.
Is the same PS case, your lordship. Kindly let the matter.
Let the
Along
matter
with
read.
that
Reach the matter reads. It will.
my lord the CD not receive yet.
Item number? Okay, wait for some time, few
Yes.
minutes. Yes.
wait, please, your lordship.
Yes.
I beg to mention item number 49, my lord. Should this matter may kindly be taken up in the next week, any date, my lord. Today my senior is out of station, my lord. Item 49.
After 10 days.
Lordship, there is an interim.
Interim order passal shall continue till the next date. Give a date after 10 days.
I'm obliged.
May I please, my lord. I beg to mention item number 3, my lord. Bankers Council is Arbora is suffering from dysentery. Can it be on Monday, my lord?
Monday.
Similar prayer for item number 12, my lord. Come on, bless you.
May I please, your lords?
Yes.
I beg to mention the matter criminal revision petition for admission, your honor, may be listed on 28.
What is the state service complete?
Yes, your honor. Service. Yes, your
Are you sure?
honor.
If you are not sure, not now. Go and verify. Yes, next case.
Okay.
Hey, please, your lordship. Lordship, I beg to mention a bail application for listing, lordship. The matter is pending for a long period of time, lordship.
Bail. No date fix.
So that's fixed.
439. Yes.
Sir, lordship, matter may be fixed on Monday, lordship.
Monday may not be possible, no? Tuesday.
Please, your lordship. Lordship, I beg to mention for listing criminal petition number 426 of 24 is for orders, lordship. 482 petition, lordship.
Why orders?
Lordship, the service was awaited. Service was awaited. That's why, lordship.
Submit is not yet complete.
Service is not yet complete,
Okay. Wednesday next.
lordship. 29.
I also have a similar prayer, my lord. In my criminal petition services here.
Wednesday.
Deeply obliged, my lord.
May I please, your lordship, I beg to mention item number 32, your lordship. In case senior counsel is out of station, your lordship, so next week matter may come, Mr. J is out of station. 32 only.
CD will just receive, my lord, next week, maybe, my lord.
Next week, give a date. Next Tuesday. Okay? What will be told?
No,
Not
fourth,
fourth,
no,
CD is
CD.
there. When will he be available?
Next week, my lord.
Give one Wednesday,
Wednesday.
29,
Huh?
29.
29.
Interim order may continue.
Yes, interim order.
Obvious.
Sir.
May I please, your lordship? My lord, I beg to mention, my lord, item number 59, my lord.
59.
It is relating to the POCSO matter, my lord. On the last occasion, your lordship was pleased to ask me.
Somebody has withdrawn this.
Withdrawn.
Withdrawn with the liberty, my lord.
Yes, with liberty.
That.
Back to installation. But this is criminal petition kindly for Monday, madam. Matter relates to Zimma, madam. On Monday, madam.
Muson.
Human metaphysics.
Muson, my.
Muson.
Muson.
Oh, Muson.
Please, your lordship, listing of one criminal petition on AB for withdrawal, my lord, on Monday. Evening.
May it please your lordship, I beg to mention a criminal bill for listing. The matter is pending for a long period of time, so lordship.
Admitted. Appeal is admitted, criminal appeal.
He has been convicted.
No, he has
No,
been
no.
convicted, therefore you have filed an appeal.
Yes,
Whether appeal has already been admitted.
yes.
Now, what stage? LCR received? You are not aware, then no, don't mention.
No.
Yes.
Order has been received and
Why you want that matter to be listed? Tell us.
lordship, he has been convicted for.
No, he has convicted,
Yes,
we know.
and
Therefore,
he
you
is
have
already
preferred an appeal. Appeal has been admitted. LCR has come. Now, what do you want?
Actually, he already completed 4 years, so.
Already completed
Four
4 years. What
years.
was the period?
It was for 8 years, so he completed 4.
So you say that you want a bail. You have filed an IA.
No,
Then
my
how can you
lordship.
grant a bail? If you seek a bail on the ground that he have completed half of his, or you can say that we want this matter to be listed for orders so that we can fix it for hearing.
For hearing, my lordship.
For hearing, we cannot give this matter for orders.
Only for receipt for order.
Orders listed for orders next Tuesday.
Put in order.
Is there any column in the mention memo that there is it can be listed for hearing? No. Yes.
You have to.
Give
file
the
a
mention memo for.
You have to
for
give a
orders.
mention memo. Ask someone.
Mr. Professor, just
No,
where is your mention memo?
you have to give a mention memo.
Yes, I may tell her what to be done, please. Yes.
I have prepared the written argument in connection with I will submit it.
Yes, Mr. Abedin.
May I please, your lordship?
Abedin, yes.
I beg.
May I please, your lordship, my lord, item number 9. Can it be listed on next Friday, my lord? In the meantime, another order has been passed on 4th.
What is that order?
That is order, this ultimately first order was non-billable and then non-billable along with PNA.
Now, how many days you are absent?
3.
3 days.
Yes, ma'am. The 4th was in.
Are you having the copy of that order?
Yes.
Okay, wait, we'll see.
No, then
May I please, your lordship?
Yes.
I beg to mention for listing of one criminal petition, lordship. And it was last posted on 5/6.
At what stage? Admission, orders,
Orders, lordship.
service is complete?
No, lordship.
No. Okay, orders next
Orders.
next Wednesday.
Next week. How long?
29.
This matter has been wrongly listed in withdrawal column losses. Whether my prisoner is behind the bar for more than 120 days in custody losses. So someone has mentioned and wrongly listed this matter on withdrawal column losses. Even official data losses 25,024 losses. LC has been received.
Somebody made a mention. Kamal Kumar Deka.
he is not the one. Maybe the number
Wrongly,
is wrong.
wrongly
Number is-
number
But
was
LC has
obtained.
been received losses from the Magic Court losses. So matter we taken today, so there 120, more than 120 days in custody, Lordship.
Scan copy received.
Inform the wildlife council. Wildlife council, no, my lord. Wildlife council is there, my lord.
Huh.
Dixit Gogoi.
Inform them, we'll take it up.
Lordship.
Inform them, who is Mr.
Dixit-
Mahajan?
Dixit Gogoi and B. Sharma also there.
Okay, you tell them, ঠিক, okay.
Now,
Let them go through the scan copies, we'll do it.
Mongim da আছে বেলেগ।
I agree, Your Lordship.
Yes.
Petition with liberty to file a fresh.
What liberty, tell us?
Earlier in this petition, Lordship, there is quashing of FIR only.
Yes.
In the meanwhile, charge sheet has been submitted. So
You want to
Lordship,
challenge the search?
we want to FIR and.
You are not aware of the recent judgment anyway, you want to withdraw it. The learned counsel for the petition
M. Hussain
submits,
on behalf.
submits that you want to withdraw this petition with a liberty to file a fresh. Prayer is allowed, list. Accordingly, the criminal petition stands dismissed on withdrawal with a liberty as strict.
Much of it.
May I please, Lordship?
Yes,
Code 39 application, my lord.
yes.
And as on date 69 days, my lord, in custody.
Where is the FIR?
FIR is page 9, my lord, page 10, my lord. Actually, lab appears, my lord. Both are in the same village, my lord.
What is your age?
22, my lord. In the same village, and all the family members has been made accused, my lord.
When
Father-
can we have the
No, no,
minor POCSO?
POCSO 4, and they have not made the party.
I subsequently I made party, my
No,
lord.
no, but their registry has committed a mistake. Because IA was there, IA was allowed, respondent is not made a party. Full stop.
I have submitted, my lord.
Huh?
I have submitted.
Oh, yes, sir.
Okay. IA. This court under its order dated dispose of IA in this case.
It is
454.
in the file.
There is a dispose of IA along. I have seen it.
ফাইলটো লগতে থাকিব।
Huh.
সেইটো
This
কোন-
court under its
কোন
order dated
কেতিয়া ল'ব?
order dated 17/5/2024 passed in IA criminal number 454/2024. Implemented the informant respondent number as in respondent informant slash victim as respondent number 2. Full stop. It is submitted by the learned counsel for the petitioner that he has submitted part in terms, it is submitted by learned counsel for the petitioner that in terms of such order, he has submitted the detailed particulars before the registry. However, name of the respondent number 2 is no, however, respondent number 2 is not yet in the name of respondent number 2 is not yet incorporated in the. This is Ruhul Amin.
Yes.
Huh?
Yes.
Okay, nalage.
Already there, my lord.
Agor ki nalage. Full stop. I will call for the case there. When? Early given, early date.
Gauripur on 31st.
31st CD. Huh?
And notice may be issued to the
Oh,
respondent.
Notice to the respondent number 2.
Please,
Register for
it will take-
notice to the respondent number 2 be issued in terms of the notification dated Deepak Nayak.
Deepak
In
Nayak.
terms of the determination made in Deepak Nayak versus state of. So it's in the
State of Assam, state of Assam. 3rd June, my lord.
3rd of June.
3rd June.
Item 4.
Yes, where is the affair?
FIR is at page number 13, my lord. That on POCSO was incorporated, my lord.
Where is the girl now?
That was recovered, my lord.
Okay, when?
Vishwanath, my lord, on 4th.
Any respondent is made party?
My lord, informant.
Notice-
respondent-
Informant is party?
My lord.
Notice to informant.
Uh,
Through
I'll
in
also
terms
take
of
dusty
Deepak
service,
Nayak.
my lord. I'll also take
Not
dusty
dusty service. Where is the
for
provision of taking dusty service in a criminal case? Tell us. Dusty has been provided under Deepak Nayak. Do that, yes. That is the dusty for criminal.
Fourth June.
Hello.
May I please, your lordship.
Yes, where is the FIR?
FIR is at page 11, lordship.
Is-
Petition is under 420 and 408 of IPC.
How many days?
25 days.
Bora sir?
Matlab, see, otherwise, matlab, it's from Forgery, matlab, a short date,
Monday,
Tuesday, matlab,
Tuesday.
Tuesday.
We are inclined to grant him today. What will you do?
Lordship may consider
Tuesday, matlab, if not, matlab,
Tuesday.
deeply.
CD Tuesday.
it's before, I mean,
Non-APS for the petitioner on call. Yes, where NCB?
Yes. Lot.
Okay, after some time we'll call it. Inform the NCB. Case diary, when?
Please, your lordship. 26 days behind the bar, your lordship. Monday.
Gitanagar,
Wednesday?
fourth, 5th, matlab.
Lordship. Item 56, on AB.
Report is there?
Report আছে না?
As per my information, my lord, petitioner
FIR registered.
number 2 arrested, my lord.
Huh?
Petitioner number 2 has been arrested, my lord. Thereafter, an FIR was, my lord, registered, but case number and sections I have no information. my lord.
Okay, Mr. Parasar, we are taking it at 2. Or you have a information, ask you, some of your colleagues, what is the case number?
At 2,
If list is over, we'll not come back at 2.
my lord, my lord.
এইটো case register হৈছে নে কিবা আছে না চাগে?
One case is registered. We sought for information. One case is registered, accused number 2 is arrested. So petitioner number 2 is arrested. So anything is there and what is the material, then we can take it up.
Bless.
Or we can give him a liberty to file a with the copy number. Yeah, moment he gets the number, then he can.
Yes, sir.
On an affidavit, my lord, I will bring on record the, my
You
lord,
can do that also.
my lord.
Yes,
the
you can do
FIR,
that. Yes. Let us see what is the.
My lord, deeply. My please, your lordship.
Case diary.
Kindly consider interim further because he's a government servant and FIR is of November 2023. The 41 CrPC notice was effected in 15 November 2023, lordship. And suddenly on
Where
13th,
is the FIR?
FIR is at page lordship 12. 15 will be the
15.
copy which was
When FIR was lost,
2nd November, lordship.
allegations are serious. We want to see the statement of the.
Lordship,
guard.
because the government,
Maybe government servants,
But also
those
354
days are gone.
lordship, edit on a letter.
You don't have any immunity, and if you have, you would not have done like this serious allegation by the, is not it? Allegation is serious.
Only part is, we have already appeared, statements were recorded in 15/5 itself.
Then where you apprehend?
Lordship, on 13 May, they have come to the office of the petitioner number 1 at Jorhat. Suddenly out of nowhere, lordship. That is the apprehension.
Have the instruction.
On the fourth,
Port. Application under Swensu. It is submitted by the petitioner that the petitioners were petitioner appeared before the vote,
Yes, lordship. 15/5, 2020.
appeared before the
IO.
IO on 15,
5, 2023.
15/5/2023.
15 November, lordship. 13/5 they have come. 15th of November.
We are fixing it on Monday.
Lordship, I have the copies. Which
Copy of
says
what?
that they have appeared,
Monday,
lordship.
28, my lord. Monday, is because tomorrow is holiday. 28.
That they have appeared, lordship, on 15th. 15/11/2000.
It is submitted by the learned counsel for the
I also have the petition number 1.
petitioner, that petitioner number,
1 and 2.
both the petitioners appeared before the IO on 15/11/2023. On the basis of a notice under section 41 within bracket A bracket comma B within bracket Roman 2 CrPC on 15/11/2023 at 1:40 PM, and both the petitioners had got their statements recorded. Accordingly, however, it is the case of the petitioner that once again the concerned IO has attempted to arrest them. Full stop.
On 13/5, they have
On
come to the order.
13/5/2024. Considering the above submission as an interim measure, it is provided that no coercive action shall be taken till the next date. List this matter on
7th of June.
7th of June. Highly obliged. We'll see. Highly obliged. The IO shall ascertain the correctness of such statement while sending the case diary for perusal. Yes.
Pending item 1.
One. So, sorry, my lord.
Yes.
My lord, actually file is with my lord, Mr. D. Google, my lord. So
Okay.
kindly, district Google, my lord, kindly little accommodation, my lord, kindly fix on Monday, my lord.
Day. Monday. এইবিলাক order আজি ফটাফট চহী কৰি দিম। Yes.
Also on item 6.
Made please, your lordship.
Yes.
My lord, there was the first round of litigation that DB
First
case,
round of litigation was DV Act.
DB Act,
Section
that
12.
was up to High Court. It
High
was
to House Court.
My lord.
Where is the bar? Your whole case is that by suppressing the earlier proceeding, it was filed. Suppose it was a suppressor. Is it a material fact? Is it vital, or 125 is not maintainable when section 12 of DV?
We cannot say that it is not maintainable.
Then if not maintainable, whether withdrawal is a material, can that be a ground of causing a what?
Not passing, my lord. It is a revision. petition.
Revision, that is.
So your lordship will turn to page
What
6.
is your
my-
ground? Tell us.
Yes, my lord, page 6.
Page 6.
Suppression of material facts, that has been over, my lord.
Okay, that we that.
Now your lordship, ground number 5, page 6.
Page 6.
Yes. Your lordship got it.
Hmm.
I want to say that there is no res judicata principle applied. But my humble submission before your lordship, as the earlier litigation, it is decided that there was no violence against the petitioner. So in the maintenance petition, it is alleged that she was driven out, she was tortured. So OP is bound by that decision on that point.
Okay. Then,
Now your lordship would be pleased to see ground number 6, page 8.
hmm,
It is a hypothetical decision of the court below, my lord. It is said that no wife live without trouble. It cannot be said that wife will not live, when wife only live when there is trouble.
can that
But
be
it's not a
decided?
universal
Sir,
principle.
you are a seasoned counsel. Can we decide all this in a revision petition?
My lord,
2000 is awarded.
2000 awarded.
2000 awarded under 125.
My lord, my humble submission before your lordship. My written statement is this, my lord. I earn only 8 to 10,000 rupees.
Hmm.
She said that 20,000 rupees.
Hmm.
And court finds that there is no proof of income. On evidence, it cannot be proved that I am earning 20,000.
A beggar is to maintain his wife.
That is
A
there.
monk is to maintain his wife.
That is there, my lord. But in that case, my lord, my humble submission will be before your lordship. 2000, my lord, no child is there. it will be on higher side because I am a day wage laborer, my lord. I am a day wage laborer, and your lordship will be pleased to see that order has been given from the date of filing of the petition. Now, my lord, there is an area of 70,000 rupees and 5,000 cost has been imposed on me. So, my lord, area plus 5,000, 75,000. And learned court below, my lord, did not say anything that how area will be recovered. No.
It is to your advantage. Do you want a clarification how it is to be recovered? We can clarify it.
Regarding that cost 5,000, my lord, and quantum of maintenance, my lord. There may be some interference.
No way out.
In that case, my lord, let me withdraw.
Mr. Sheikh, learned counsel for the petitioner submitted. He has instruction to withdraw this petition. Accordingly, prayer is allowed. This petition is dismissed on withdrawal. Yes, next.
Oblige, your lordship.
Mr. Pathak, the police says that we sent it to forensic in the search sheet and forensic gave clearance. No.
They were confused.
Okay.
Right.
But whereas the forensic says it cannot be it's not conclusive, cannot conclude.
Yes.
But learned magistrate has said that yes, if further investigation is necessary because you have not even collected the thumb impression. What is wrong on that and why should you interfere in under for this application?
I'm obliged, madam. This query was, in fact, I was asking. Learned magistrate has directed in the Narasi petition that was filed. I'm not going into those technicalities after 3 years, 4 years. Learned magistrate has said that since it was inconclusive, so you better go to the sub-register.
Not only inconclusive. Rajesh magistrate say, okay, it can be inconclusive, but in the investigation, it is specific allegation that these are not our signature. We have not executed the sale deed.
Right.
Therefore, the learned magistrate rightly said, according to us, that you collect the thumb impression, that will give everything clear. To have this investigation come back to us, if that is not yours, if that is the of the land owner, then fine.
Right.
If not, then criminal will proceed.
What I
Where are you apprehending at this stage? It's better
no,
for
I
you
am
to
not
give you a
apprehending anything. What I
clean
wanted,
sheet.
page 60, I am obliged for this query, my lord.
Yes.
Page 68, if your lordship look. Learned magistrate said that statements were not recorded. In fact, statements under 161 was I am not on that. Then the third line, any attempt to verify the authenticity of the disputed sale deed, that is already ceased from the office of the sub-register. This is what is happening. Now, what may I submit, my? The disputed sale deed is with the IO. Now, in such situation, after the Rambabu's case of 1980, that 73 will not apply, 2005, an amendment was brought in as a section 311A. The magistrate had the power that the sale deed is there. Now, you are saying it is not your signature, give your signature in perimeter order 26 rule 10. In order 26 rule 10, that was in a CPC. Rambabu said that same thing is not there, so a better legislation should be brought in. 311A, it says in such a situation, the duty of the magistrate is, it was brought in 2005. If a magistrate of the first class is satisfied that for the purpose of any investigation or proceeding under this code, it is expedient to direct any person, including an accused person, to give specimen signature or handwriting, he may make an order to that effect. And in that case, the person to whom the order relates shall be produced and shall attend at the time and place and specified, and he shall give. Now, what was the duty of the magistrate here was, what was the duty that since it is your Narazi petition and you are saying that it is not your signature, under 311A, give your signature, which will be an admitted signature now. I give it to IO because that FSL report says it is inconclusive. So we want admitted signature. Let it go to FSL. Here, my lord, I have the instruction also to submit that let both the accused person's signature and thumb impression and his thumb impression, because it's a matter of family dispute, something like that.
2, 3
If I
brothers.
am not on that.
3 brothers.
It's a statement from the bar that I will, if your lordship so directs, but both the accused, I am the accused and the informant be summoned by the magistrate, take their signature under 311A, which will be an admitted signature, and let it be verified again by FSL reports. FSL.
No, that is fine. That is not an issue.
My lord.
That is fine. But either way, magistrate not doing it unto itself and asking the officer to redo it will not be a ground to exercise our power of revision.
The magistrate has asked it to redo it from the sub-register office.
Of course, because they will clarify, if necessary, clarify that.
Right,
For the
but-
purpose of investigation, you may will not interfere with this. Then even you can take the original books where some impressions were given, have sent it to the
But
expert.
that is already a seized document with the police.
No, seized document is the cell deed.
Sealed it.
But
He is
there
saying in
are
the FIR.
books where everything will be
My
there.
lord, he is saying in the FIR that in the cell deed, because the limitation of for declaring that as void has already gone. Now, what he has done in the Naraji petition after 6 years, the closure report was of 2019. He says that this cell deed, it is not my signature. Cell deed is with the police. Now, this notice I did not, I could have mentioned this when had I got a notice from the Naraji petition. Now, the issue is cell deed, the IO has seized. This is a disputed document. IO had sent the signature, but they could not give a conclusive thing. But 311A, in such a situation, magistrate has power.
No, magistrate having power is not an issue. Here issue is whether non-exercise of that power will be so fatal to interfere with disorder.
My submission would be that since the document is with the police, dispute is with respect to the document. Signature has to be verified of that document. Now the admitted signature, FSL report said admitted signature, everyone. Admitted signature, the magistrate would have taken it instead of directing the IO to go to the sub-register office.
I think we can make it clear. Sub-register office is authenticity of the disputed cell deed. It's a wider word use.
And
That will mean of verifying whether this cell deed is relatable to the record of the sub-register.
And
I think that is the intent of this
In
order.
the interest of investigation, may I also, your lordship, what falls from your lordship, that is correct. In the interest of, because this dispute is hanging, and as a result, my business is a big claim. Since this dispute is hanging, let the magistrate take our signatures, both me and accused.
Let us do one thing.
My lord.
Let the investigation proceed as per the direction. We are just issuing a notice to the other side.
Right.
Let them also come, and if your procedure they agree, then we'll in a specific how it is to be done. we'll
Nothing
proceed.
adverse will happen to them. I am also ready. Let them also submit.
Okay, we'll see that. If that is a proposition, we'll see that. But for the time being, we are not staying this order. Mr. Pathak Larned, Senior Counsel, assisted by Mr. J. The present application is filed assailing an order dated 6/5/2022, whereby the learned magistrate, Chief Judicial Magistrate, Kachar Silsar, has directed for a further inquiry in connection with Borkhola PS case number 240 of 2019, which was ended on a final report. Full stop. Issue notice. Full stop. Returnable on given date 27th of June 2024. Issue notice also on the interim prayer. Full stop.
May I have one more indulgence?
Yes.
Pendency of this case will not come on the way for the IO to take admitted signatures of the
Okay.
that is his case.
as we have, as this court has not granted any interim order, the IO shall be at liberty to obtain the admitted signature of the parties on of the alleged to have been
admitted signature of the complainant.
admitted signature of the complainant or the thumb impression of the thumb impression of the alleged seller from the sub-register office as has been directed by the learned magistrate. Full stop. Full stop.
And-
Okay, we'll on the next date.
And obtain FSL report as well.
And okay. We'll not say so much. Let them inquire. Will
I thought, because it is not a dispute, that I am also ready, let them
No, no,
also.
that's why we say let them come. If say that we have no problem, let us have all this or any other forensic examination. We'll pass that
Fine.
on in the investigation. Okay, next.
Obliged, your lordship.
May please your lordship.
Heart, Mr. J. Kolita, learned counsel for the. Now, who is the authorized signature? Whose
Lordship,
signature was there in that star?
The accused lordship, other accused person, that is accused number lordship, 5,
Hmm?
5 and 6 lordship. In the claim petition,
Accused number?
5 and 6 lordship. Of
Petitioner number?
lordship, page number 18,
Page number?
18. Where this petition.
Where is the sake?
Check lordship, they have not even sent the check and the lordship, even postal receipt and the bank receipt also not sent. Only these 2 pages, sir. And no abatement has been made, lordship, that with this petitioner issued the check.
Heart, Mr. J. Kolita, learned counsel for the petitioner. The present application is filed for postment of NI case number 10 of 2023. Full stop. The case of the petitioner is that the alleged check was issued on behalf of the company, namely,
Colorban Key Limited, page number 18 also,
page number
18.
18, namely,
Number 1, Colorban Key Limited.
Pillar PALL silo, page 18, my pencil mark is 1. Come on. Company, full stop. However, accused number 2, 3 and petitioner number 2, 3 and 4 has also been named as accused, being director of the company. Full stop. Mr. Kalita, learned counsel, submits that not a single whisper has been made as regards the role of the present petitioners as director in commission of the offense under section 138 negotiable instrument, and accordingly such case cannot be allowed to be proceeded against the petition. First of issue notice returnable after 3 weeks, returnable on given date. June 21st, 2024. Full stop. Considering the matter in entirety till the returnable date, it is provided that the NI case number 10 of 2023 shall remain suspended so far relating to the 3 present petitioners, namely Sanjeev Kumar Swenso, Nam 332, President Swenso.
Lordship. Deeply obliged. Item 9.
Heard Mr. J. Abedin, learned counsel for the petitioners.
My lord, I informed you about another order that was passed on 4th. My lord, on 3rd.
The petitioner is an accused in Sessions case number 173/2022 which is pending for trial before the court of learned
Additional session. judge.
additional session judge, comma FTC, comma Sonitpur, Tezpur. Full stop. Though the petitioner was initially arrested, however, subsequently he was released on bail by the learned trial court under its order dated
21/10/2022.
21/10/2022. Full stop. Subsequently, the petitioner participated in the trial. However, on which date? First date?
My lord, first date is 16/2/2024.
Pace.
My lord,
However, on 16/2/2024, the petitioner was absent without steps. On 16/2/2024, when the matter was fixed before the trial court, the petitioner was absent without steps. Accordingly, a non-bailable warrant of arrest was issued against him, fixing the matter on 13/3/2024. On 13/3/2024, the warrant was returned unexecuted. Accordingly, a fresh arrest of warrant was directed to be issued, returned unexecuted with a report. That the petitioner was not found at his given address, and that the petitioner had gone out of station for walk. Full stop. And accordingly, fresh NBWA was issued, and the matter was again fixed on 4/5/2024. On 4/5/2024, the learned trial court however, the learned trial court below on 4/5/2022, considering the long pendency and the nature and gravity of the case, the petitioner was declared as absconder.
yes,
Huh?
my lord. Yes, my lord.
Absconder, and proclamation was issued. Full stop. When this application was filed?
My lord, on third.
Full
On
stop.
third, my lord, before that.
Mr. Abedin submits that he could not bring this order dated 4/5/2024 before this court, as the present petition was filed on 3/4/2025. So, Mr. Abedin,
3/5.
3/5. Mr. What are the grounds for non-appearance?
My lord, may I just state, my lord? My lord,
Yes.
if your lordship could see from page 24 one thing, my lord, in order to show the conduct of the petitioner, my lord.
No, conduct we have seen. You have taken steps. That let us not waste time on that. What
My
are your grounds for this period?
My lord, for the first date, my lord, actually I informed my engaged counsel, and I was, my lord, I am.
Where is that? Where is the statement?
My lord, that is page 12.
Page?
Page 9, my lord, annex, paragraph 12 is the ground for in respect of both the dates, my lord.
Referring to the statements made in the petition, Mr. Abedin Learned Counsel submits that the petitioner was absent on
16/2/2024.
16/2/2024.
Army duty in Nelia, Jimithang, Tawang.
16/2/2024, for the reason that as a driver, the petitioner's vehicle was hired, and it was under army duty in Nelia, Jimithang, Tawang, Arunachal Pradesh. However, he informed his engaged counsel and requested to pray for another date. Full stop. However, his counsel did not make such a prayer. Full stop. As regards the date on 13/3/2024, Mr. Abedin contends that
My lord, on 11/3, there was a landslide.
full stop, it is submitted that the
Yes,
petitioner
mm.
could not return from Arunachal Pradesh. Could not return from Arunachal Pradesh due to a landslide on 11/3/2024. Full stop. In 11/4/2024. Full stop. It is further submitted by Mr. Abedin that the petitioner has all throughout been present before the learned trial court below, inasmuch as whenever he had some difficulty, he has taken due permission from the court, and therefore the petitioner therefore the petitioner may be allowed to participate in the trial without being put behind bar. Full stop. Consider the submissions made advance. Full stop. This court is of the view that petitioner should approach the learned trial court, showing the aforesaid reason, which in the considered opinion of this court, if properly, because there is nothing to say you are in army duty and all, it's a hired vehicle. This can be a good ground for recalling of the NBW, be that as it may. That's all. Be that as it may. That is enough. Be that as it may.
Is it that nothing to say that army duty? Is it part of the order, my lord?
So we have said it. We have said that can be a good ground. Good ground for withdrawal of the recall. Recall of the non-bailable arrest of
My lord,
warrant of arrest and subsequent order dated 4/5/2024. Full stop. So accordingly, this court is of the view that the petitioner should be relegated to the learned trial court below. Full stop. Accordingly, it is directed that the petitioner shall approach the learned trial court below with an application for recalling the NBWA and the order dated 4/5/2024.
My lord, three orders, 16 to 2024.
NBW I have said plus then 4/5 is mentioned. 4/5/2024. 4/5/2024 with reasons. Full stop. In the event such application is filed, the learned magistrate shall consider the same in the entirety of the matter. Full stop. Till such decision application is filed and a decision is taken, the order dated and the NBWA and the NBWA issued and the order dated 4/5/2024 shall remain suspended. Shall not be given effect to. That much.
That much is hopefully enough.
And
Deeply obliged.
yes,
Is it disposed of, my lord?
disposal.
Then, my lord, I think one thing, in order to keep that petitioner in some kind of a duty bound, he will appear within 2 weeks or 3 weeks.
Give a date. Give a date.
Yes.
In
My lord, after-
appear before the
After 15 days, any date, my lord.
after appear before the learned trial court below on or before
15 days.
12th of June. On or before 12th till such application is filed, till such appearance or filing of an application, the matter the NBWA shall remain suspended. And all these orders can equal. Yes, dispose of.
Deeply obliged.
Yes.
My lord, in this case, I have could not annex the order.
That is what
Taking consequence order.
highest time we
I
have
am
spent in this case searching the order.
Yes, I am also, but
You
it
you
is-
pay
it is-
cost.
I will.
Huh?
I will, I mean this,
What I mean, you withdraw a file afresh. Mr. Ahmed Learned Counsel for the petitioner submits that inadvertently the order dated
order dated.
order dated
14/8/2023.
Order dated 14/8/2023, passed in CR within bracket DV case number 317/2023 has not been annexed. Accordingly, he submits that he may be allowed to withdraw the present application and file a fresh petition with annexing the aforesaid with curing such defects. Mr. Prayer is allowed. Accordingly, this petition stands dismissed on withdrawal with a liberty. Hello.
Thank you, Your Lordship.
Hard. MS Borua, R. Borua, learned counsel for the petitioner. The present application is filed assailing an order dated 29/4/2024, passed by the learned Session Judge Dorong in criminal revision number 1/2022, whereby an order dated 12/11/2021, passed by the learned Chief Judicial Magistrate Dorong Mongoldoi in CR case number 243/2014 were set aside and quashed. Okay, issue notice.
We have a prayer for interim in this.
What interim?
Because
What will you say? Then it will revive.
Considerable delay has already been caused because of the
No,
numerous
no,
proceedings.
you tell us.
Lordship, I'll
Suppose
satisfy.
we stay this order,
Lordship.
then the order of CGM will revive. Then trial will continue.
Lordship, because already delay has been Lordship or caused Lordship because.
No,
of
no,
multiple
delay is
proceedings.
caused. But only thing is that what can we stay?
Lordship will satisfy on the interim prayer, Lordship, because Lordship in the.
No, no. What will be the effect of interim? We can satisfy, that is one aspect. See, this, if I could understand properly, a person was charged by a trial court,
Lordship.
saying this, you have done this. Now appellate court discharged that person, is not it? Now, if we stay this order, a trial will continue. He has already been discharged.
No, Lordship, that's why we am assailing, Lordship, because we want the trial to continue, because Lordship, this order, impugn order.
No, you want to trial to continue. That's why you are here. But we
Lordship,
cannot
delay-
allow trial to continue without hearing the other side.
Lordship,
Your
what is-
interim order will find final order. We cannot allow the trial to continue when a person has already been discharged.
Short notice may be issued, Lordship, to the other side, Lordship.
Short notice we can returnable on 25th.
Lordship, Lordship, P. Barua, Lordship.
P. Boras. Oh, sorry.
Thank you.
Item 13.
Always it is confused R and P. Yes.
I'm sorry, my lord. Instead of 15, can it be 20th? 20. That is
Earlier question. 20.
17 is I don't know what will happen. Item 9.
May please, my lord. It
Yes,
is this,
huh?
my lord, Nalbari
Item?
case. Section is, my lord, 294, 354, C, 354, 511, and 506, my lord. All,
Yes,
some
yes.
section are interim protection may be given. Petitioner is a lecturer, my lord, and kindly see the FIR, my lord. FIR
We
is
have seen
simple.
the affair. That's why you are not inclined.
On my
Kindly interim
7th
protection, he is a lecturer of, I have stated in paragraph 7, my lord. He is the lecturer at Royal Institute of Allied Health Sciences, 25 years old, my lord. And if he is arrested, that career may be hampered, my lord.
Now, why did you, while doing all this, why did not you think?
Petitioner said that they are the informant and the accused petitioner, they are residing one rented house separately.
That is the difficulty.
That my lord, they are use the common Latin bathroom accordingly, but petitioner informant
on 4th
Short
of,
death, short death.
4th of June.
4th of-
kindly interim protection may
No,
be
no,
given.
The affair is necessarily described.
Kindly see FIR, my lord.
We have seen that. First incident shows that this is a real thing.
Section
Yes.
section is, my lord, bailable section, my lord. That is the 354C, that is the bailable only for 354 modesty, my lord.
After 354, you have gone to the 376.
354, my lord,
That is
only
the
kept
problem.
for
Next
hand, my
case.
lord.
Next case.
After filing this
LP application lawsuit. Petition number 3 is arrested lawsuit.
Hmm?
Petition number 3 is already arrested.
Hmm.
After filing my lord, other two petition number.
You also go there and come back on the day one, we will grant you bail. On the day one, we will grant
My
you
lord,
bail.
the co-accused lawsuit has disclosed the name of the present petitioner lawsuit. He has been arrested and after that lawsuit, he disclosed the name. My lord, so for the offenses.
Let there be parity. We'll grant you all on the day one.
My lord, this
CD,
is-
when?
Lordship. 11 of June.
You are a rich thief, I think so.
11.
Huh?
11.
11.
the statement is not there. Okay. I didn't think some spot date lawsuit because you have.
Date is, Mr. He will give date.
On 6 Lordship.
6th. Next item number?
Lordship, 438 application, my lord, FIR is at page 10.
No question of this interim
Other than CD maybe also.
CD.
On my lord, 11th of June.
11th?
11th of June.
Item 16.
CD interim.
On my lord,
When? 18th.
Item 17.
It's a complaint case, my lord. My lord, here the complaint is from page number 9, my lord, translate copy, my lord. Here, my lord,
Interim. CD interim. When appear within 10 days. Yes, before the IO. And pay the
21st
50,000.
21st of June. my lord.
yes, my lord, I'm ready to, we are ready
Pay
to
the
settle.
50,000. On this next date, we must see that you have already paid in terms of your WhatsApp message.
My lord.
Item 18.
Next, my lord. It's a 438 application, my lord. FIR is page 14.
CD.
My lord, interim, my lord. My lord, 138, my lord, proceeding is going on, my
Where
lord.
is that?
Yes, my lord, page 25, my lord.
Yes.
25, my lord. Annex 3, my lord. Registered that, my lord, 1/3/2024, and page 26 is, my lord. Informant and accused, my lord. Paramananda Gohai and Rajiv Kumar. Yes. I will pay my lord. For finance, for
You
finance.
are a doctor or what?
Yes, my lord.
Medico
No,
or
no, no.
PhD?
PhD.
PhD.
Yes.
What is the amount of check?
Yes, my lord. That is, my lord, 8 lakhs, my lord. I have not 36. I have, my lord, page. I have statement, my lord, as page 6. Yes, my lord.
Yes. What is the statement?
Yes, my lord, page 4, my lord, para 5, my lord. Not 36 lakhs, 21 lakhs, my lord. I have already paid 12 lakhs 70,000.
What Spencer? CD interim.
21/6.
19.
Made procedural also. 438 application, my lord. Lordship will find the FIR at page 9. Three things only, my lord. They are next door neighbors, my lord, and having a boundary dispute. And possibly, my lord, that until law is not followed in this case, my lord, I seek some protection. I
CD.
next door neighbor, my lord.
4th of
Next
June.
door neighbor, one is hospitalized, allegation is
Treatment is
serious.
still going.
That we'll see from the CD. Yes.
Public,
4/6/2023.
court of public.
Mascot.
আগত আছে
Bail hearing. Yeah, item 22.
Fair plan, please, lordship.
What is the FIR?
Lordship.
Page 11. Lodge. Case
11.
What happened to the other accused?
I don't have information about regarding
Eleven
the other.
C.
Lordship,
Two accused, isn't it?
no,
How many
I am
accused are there?
one accused on.
No, no, in the affair.
In the effect, 4 accused.
How many days?
Lordship, this is a 525 days today.
Search sheet is filed or what?
Yes, I have.
Where is
And
that?
Lordship,
Scan copy is there, but also the scan copy is not up to date. It's the last status report is of 2012-23. In the meantime, 2 PWs were examined.
How, how many witnesses total?
two examined on 14th of
No,
December.
no, how many witnesses are there?
Total
Total?
6.
Total 6 witnesses.
2 is examined.
Huh?
2 is examined.
Two have been examined
Two
out of
have been
6 on last December, Lordship.
Okay,
After that,
thereafter, are
Lordship,
you aware?
yes, Lordship.
What happened now? What is the last date?
Last date is 14th of December. Last witness was examined, and the next date actually
that is why, Lordship,
Yeah.
the scan copy is not up to date. Lordship.
No.
It was fixed on 11.
How many, any bail application, any debasing accused in this case?
Lordship.
Huh?
Debenture Lordship.
Debasing. What
Third
happened to Debasing's bail?
I'm not aware of it.
BA 2357, 2023.
I'm not aware.
Order dated 223 only, 237/2023. The present application is filed seeking regular bail. By the petitioner, namely R. Yaruibo,
Yaruibo.
Yaruibo, who is in custody pending trial in connection with
Special NDPS case number 42.
in connection with special NDPS case number 42/2023 pending before the special judge, Hojai, Assam, arising out of Lamding PS case number 201/2022 under section 20 within bracket small b small Roman 2 bracket C /29 of the NDPS Act 1985. Full stop. This court earlier called for the scanned copies of the case records. Full stop. The case record reveals that out of total 6 witnesses,
2 have been examined.
2 witnesses were examined lastly on
14th of December.
14th of
December.
December 2023. Full stop. Therefore, this court would like to go through the proceedings of the aforesaid case from 12 to 2023 till now. Full stop. Accordingly, registry to call for the
Up to date status.
up to date case records with effect from 12 to 2/12/2024 till date. Full stop.
23, Lordship.
23 till date. List this matter on. We'll have to give it. They cannot. No, 4 weeks. Give after 10 days or
First week of June, Lordship, please.
first week of June, 7th, 8th, like that. Registry to do the needful. Registry to call for this, no? Okay. Yes.
Along with the deposition of witnesses, if any.
Along with the deposition of witnesses, if any.
And 24.
Yes, Bhattagor.
In this case, your lordship is a search sheeted under section 4, your lordship.
of POCSO, your lordship, 283 days behind bar, your lordship.
Where is the records? Can copies come? Have you gone through it?
Informant and the victim has already been examined, your lordship. I am not on merit, your lordship. He says
What is the age of the victim?
10, your lordship. Eligibly. Only thing, your lordship, on merit, I have only one submission to be made, your lordship. That's, your lordship, the allegation of, your lordship, penetrative sexual assault, your lordship, but medical reports belies that, your lordship. Only that part. Otherwise, your lordship, the informant and the victim has been examined, your lordship. Probably, your lordship, further custodial detention is not required, at least to face the trial, your lordship, and to assist with defense, your lordship. Maybe released on bail, your lordship.
How many total witnesses are there?
There are 8 PW.
8 people. How many examined?
That is not on the
Two,
record.
three. No, not 3.
Victim and the informant mother.
What was the last date?
Next date is 28/5/2024, your lordship.
28/5,
Next date, your lordship.
Tuesday. Let us take it on 29th is, what is the date? 29th? Let us take it on 30th.
Lordship.
You have a copy, what is happened. We will not call for anything.
Lordship.
Okay? Or you have a copy in the meantime, what has happened, any copy
Lord,
certificate.
I'll
Okay? Okay. The present application is filed for file under section 439 CrPC to grant bail to the petitioner who is in custody pending trial in connection with POCSO case number 281 of 2023. Full stop. The victim as well as informant has already been examined in this case. Full stop. It is submitted by Mr. Bothakot that next date is fixed on
28/5, your lordship.
28/5/2024 for examination of other witnesses. Full stop. Let this witnesses. Mr. Will give the blame on Mr. Sharma. Mr. B. Sharma, Learned Counsel, submits that he may be granted some time to go through the records. Full stop. Prayer is allowed. List this matter on
Can 31st, can it be?
31st. Let us see how it progressed on the next day. Otherwise, his victim are examined. What we'll see.
Lordship.
Not sure, but we'll see.
Yeah, please, your lordship. My lord, FIR page 9, my lord. FIR page 9, my lord.
FIR page item number
25, my lord.
PA.
PA, my lord. Criminology.
It is there.
Yes, ma'am, because there is.
Anything you require his further custodial intervention?
Otherwise, yes.
Mobile is seized.
Yes, my lord. And my lord,
Materials are
he,
seized.
as per 164 statement, she implicated, she initially, my lord, the accused person introduced himself as a student of my lord IIT. And thereafter, my lord, he, my lord, committed these offenses, my lord. There are implicating materials in the 164 statement.
How many days he is behind bar?
My lord, 33 days. My lord. 82 days. Yes.
Considering which of this is a present application 439 next. The allegation is that the petitioner promised to marry the victim and taking advantage of such relation, he had physical relation with the victim and also got those intimate moments videographed and with a threat to make those videographs viral, committed rape on her. Full stop. Perusal of the case diary reveals that the statement of the victim under section 161 as well as under 164 CrPC has been recorded. Full stop. The mobile handset says his mobile,
Yes.
his
yes.
mobile handset and the videograph, etc. had already been seized by the IO, and the petitioner has been in custody since last 82 days. Considering the stage of investigation and the period of detention, this court is of the view that no further custodial interrogation of the petitioner shall be necessary. Accordingly, to the satisfaction of
First class Hajar, my lord.
Judicial Magistrate First Class Hajo. Yes,
Very please, Your Worship.
what is the affair?
My lord, if I'm here in this case where I'm seeking my default bill, it is application under section 167(2),
Huh?
167(2) CrPC,
Okay.
seeking defaultment, my lord. He was remanded to judicial custody on 11/9/2023.
11/9,
2023.
11/9/2023.
And period of 180 days had completed on 8/3/2024.
8/3.
2024.
Yes,
My lord,
There is a prayer for my lord, extension.
but
right?
extension
If it
is on which date?
my lord, just
After extension was filed on which date?
on 11/3.
Then
11/9, 11.
11/3, 11/3, my lord. That's why I have annexed, I have annexed. That is page 20.
Page
Page 20, my lord. There is an application filed seeking, my lord, sometime, my lord, to complete investigation on the ground of being not received of FSL report.
just tell me
Page
page.
20, my lord.
Page 21.
20, 20, 20.
20. Mr. Goswami, go through it. What should be, we'll take it up after some time. What should be his
Custodial period.
period that users verify,
Lord.
and when this application of
Lord.
extension was
Lord.
filed,
Lord.
and what is the principle of law as on date?
167(2).
That's all.
Lord.
Okay. After some time, or at maybe at 2, we'll take it up at 2.
Lord.
Okay.
Lord.
You just go through it. You should not have that. You have the calculation and
Lord.
what should be and what it when it is filed, and what is the according to what his case is that it is after the A3, the it is filed, it has gone. Yes. Next. Yes, Munish. Huh?
This is intermediate quantity, Lordship. Total heroin was found 19.99 gram, Lordship, and 51 days behind the bar.
Where is the FIR?
FIR, Lordship.
9, Lord.
Page 9.
13 is the operative. Sorry,
13, na?
13.
Your name is Motiur.
Module Rahman. Module. 19.
What is the quantity of the drugs?
With box lordship as per FR 77.7 gram lordship, and lordship will kindly turn to page 22 lordship.
Is
Page 22, the magistrate's order lordship, the inventory prepare lordship, and that lordship will down below lordship will in bold letters lordship.
okay, 19 point.
On 19 without the soft box lordship. And that revealed by, it also stated in the inventory lordship, that inventory, original inventory on page 21.
20.
21 is the original inventory lordship. And in the second paragraph lordship.
What is the period, total period of to complete the investigation?
60 days
60
lordship.
days, madam. 60 days. And now, my lord,
51.
the case is pending for the FSL, and also, my lord, if 60 days will complete, my lord, after 9 days, my lord. So, I pray, my lord, let my lord FSL come, my lord. Because there is still possibility of such treatment. Otherwise, my lord, the materials are there, because seizure is from that conscious position, my lord,
From pocket.
from pocket.
We do not know subsequently what.
And subsequently, my lord, I am
Many grounds will
Many
be there,
grounds will come.
8:50 PM,
that
no
will come, my lord.
information, this,
Yes.
that, many things will come.
And these things, my lord, go against us, my lord.
Will you be, it will not be possible on your part to file a search sheet by next 5 days.
Even then, my lord,
Keep in the case that
plus
these are peddlers.
peddlers and my lord, it has come up. I have, my lord, seizure and witnesses I have diagnosed.
From your pocket as per independent witness.
Plus,
Pretty ground lordship, blanket
Yes.
retention lordship, 51 days and local person lordship, but no chance of absconding lordship. Shall appear.
What is the punishment for this offense?
10 year lordship.
Huh?
Maximum 10 years.
Today is 51 days.
51. Wednesday, my lord.
Wednesday will be how many days?
Today is my lord, 57 days, my lord.
Monday. Tuesday.
Tuesday.
A last chance to them.
Because my, tomorrow and day after tomorrow, my
We
lord,
do not know.
holiday, my lord.
We do not
Holiday,
know.
my lord.
That's why
Monday is there, my lord. That is why I'm saying, my lord.
you will fail, we know that.
At least, my lord.
Mr. Munir will be out on Tuesday. List on the prayer of Mr. MP Goswami, list this matter on Tuesday.
Much
That
obliged,
much
your
only, not beyond anything.
No.
Much obliged.
Even, you know, the FSL also, my lord, not ready, my that is.
Is it necessary always that you
It-
should
it
file
is
with
not
the
always-
FSL?
not-
That can be given later.
Later, that is just.
Some recent judgment have also
Less,
come from.
less.
Yes,
Last,
Much obliged.
we'll see on Tuesday.
last.
Yes, that will be.
Yes, then.
Well, I am behind bar since last 28th of March.
Item number?
28. Not in this case, POCSO has been very casually
the
invoked in this case.
Case has been, my lord, succeeded, my lord.
Okay. It is submitted by Mr. MP Goswami, learned counsel for the petitioner, that that investigation in respect of Tamulpur PS case number 66/2024 has already been completed and search sheet has already been filed, being search sheet number
55/24 dated 28/4/24.
full stop. In view of that, the present bail application stands closed. The petitioner shall be at liberty to approach the learned trial court, learned court below, not trial court below, seeking a regular bail. And in the event such application is filed, shall be considered as per law.
29.
May I please, Lordship?
Yes.
You see, 439 application, my lord. On earlier occasion, my lord, on 164 CrPC statement of the victim girl was, my lord, called for. And in this case, my lord, registered under section, my lord, 365, my lord. My humble submission is that, my lord, the alleged victim girl, my lord, attained the.
That case.
Yes, my lord, yes.
Bhagya
My lord,
wala.
yes.
That marriage.
Yes, ma'am. There.
Anything?
Yes, my lord, 164 statement recorded on 9/5/24, my lord. Thereafter on 10/5/24, IO has filed an application for adding, my lord, section 376. That's it.
A statement is there, victim statement.
Yes, my lord, 164. Second question.
How many days?
As
19
on today,
days.
19 days, my lord. As on today, 20 days, my lord.
How many days? 19 days.
As on today, my lord, 20 days and already completed.
Let him go.
Yes.
Precision application under 439. Connect with the arrest to Divo. From the statement of the victim, what is her age actually? In this she has said 18. Anything?
Anything, my lord, otherwise, my lord, from the 164, it reveals that,
18.
my lord, initially there was a love relation, thereafter, my lord, by inducing her, my lord, to
From
commit
the
physical-
164 statement of the victim girl, it is seen that the victim is 18 years of age and she had a relation with this accused since last 2 years, no, 1 year. Had a earlier love relation going on. And accordingly, she eloped with the boy. However, she has alleged inducement in inducement in having a sexual relation. Full stop. Considering the materials so far collected and the stage of investigation, and also the period of detention, this court is of the view that no further custodial intervention of the petitioner may be necessary.
IO has also filed an application for adding 370.
Okay,
That is not,
in the meantime, IO has also added
not yet added, my lord.
filed an application
Application.
for adding section under 376 in as much as the case was registered earlier under section 365 IPC. Full stop. তাৰপিছত দি be that as it may কৰি এইখিনি কথা দিবা accordingly to the satisfaction of
As the them overbearing.
as the
Not Shalmara at overbearing.
not
Not Shalmara. Much obliged, lordships. Obliged me.
25,000. Yes, next case.
In this case, office note says that some statement of accused was called for. That is not been received for the office note.
Implicated on those witnesses, madam.
Where is the order, earlier order? This is for narcotics.
Yes, not, not rejected by your lordship. They regularly come before the lord.
No, why this office note?
Earlier lordship statement of accused.
Where is the
examined-
order calling for the statement?
That lordship.
Okay, 29/4.
Three witnesses were examined, my lord.
Who are they?
One was the intelligence officer who made the seizure, my lord. And they are subsequent to one expert.
Where is
was
the FIR?
Your lordship find
It's a complaint is, this NCB complaint, where is?
Complaint, your lordship.
Please start from page 11.
Complaint actually seizure took place from one Ranjit Singh, madam.
Okay,
Was
then
implicated on the basis of the statement under section 67.
you have been implicated on the basis of the statement from whom the recovery was
Was
made.
made, yes.
Where is that? Where do you go to get that?
That your lordship, relevant page, I'm coming to it, your lordship, right? That,
Yes.
that page. Okay. That page 53, madam.
Page 53.
Internal page 43, madam.
You are Pramod Yadav.
Pramod Yadav, thank you.
Okay.
That as per a voluntary statement of arrested accused Ranjit Singh, Pramod Yadav is is accomplice accused in connection with seizure of so and so, which was recovered from the conscious person of Ranjit Singh and the truck bearing number so and so. Arrested accused Ranjit Singh was disclosed that his voluntary statement Pramod Yadav provided the truck number so and so of trafficking cocaine, based fentanyl, cough syrup. Pramod Yadav admitted in his voluntary statement he was involved in the trafficking cocaine, fentanyl, conscious.
Now, who have been this examined? Where is the this scan copies?
Like,
How many witnesses examined?
three
Who are
witnesses.
they?
Meena
Seizure
Kumar,
witnesses.
Meena Kumar,
Seizure is admittedly from whom?
only from Ranjit Singh, madam.
Daljit Singh. Ranjit. Ranjit Singh. And you have been brought into in terms of page 53.
This was statement made by Ranjit Singh.
Okay, so your case is that only on the basis of two statements, 167 and voluntary, I cannot be, even there is no scope, therefore scope of conviction.
This is because of the
Decision judgment.
Tufan Singh judgment, madam. So
Tufan Singh.
my testimony and the testimony, and now what happened, they also relied upon some call data records. That paragraph 7, they have stated that Pramod Yadav Pinky was frequently connected on mobile phone number of arrested accused Ranjit Singh. On analyzing the CDR of mobile number so and so, during the period 1/10/2022 to 1/1/2023.
These CDRs have been exhibited by somebody.
They have not been seized, madam. No, seized. They have not relied upon, and no officer of any company, my lord, has been examined, my telecom company, my lord. They have not cited as witness in this case.
Okay.
So they are not relied upon the CDRs also. So basically, on the basis of the statement made by the co-accused, I have been implicated by.
Yes. Well,
Lordship has seen
Hmm.
the materials collected during the investigation against the petitioner.
yes, this
Page
is the
64,
this is the
page 50.
statements. Any other material?
Lordship, page 53, paragraph 7, last paragraph.
Now, what is the seizure, anything regarding the CDR? That is what I was asking.
That lordship, I have to consult the lower court.
Huh?
I have to
No,
go
no,
through the
because I have got the records, but they have not relied upon those documents.
lordship, I am relying on was judgment. Paragraph 18 and 19.
The list of documents are say at their night.
Nothing here, nothing here.
Was by this honorable court.
This is 133.
Yes, sir.
Accomplice. Accomplice, my lord, that if the statement is admissible, then only question of accomplice will come back. And had it been a confession, judicial confession, right?
That will become evidence
Yes, sir.
when he will come and say in the court.
Yes, sir, obviously. Sir.
So
But
that
if now in this case, charge was framed on 10/8/2023 and charge under section 29 was in framed against the present petitioner. Lord.
now because there's a recent judgment, my
The
lord.
learned trial court was conscious about the fact, the involvement of the present petitioner also.
Justice Cole's judgment, my lord. Rama Kohli, my lord.
And out of 8 witnesses, 3 has been examined so far. Lord.
That will not improve the case of the NCB, my lord. There your lordship will find it. Paragraph 11 to 12, my lord. Having gone through the records and developed statement from the outstanding in order pass in the case, that accept the voluntary statement of A1 in the first case and the respondent recorded. Primarily, no substantial matters available to prosecutor in connection with respondent will allegate.
That's why, in fact, Mr. Kyle is aware. In similar cases, we have said that this cannot be, therefore, there is a likelihood. We are saying there is a likelihood of acquittal. We cannot give clean sheet at this stage.
Definitely.
That's why we have granted. But anyway, I say, we'll come back and dictate the order. Contends that on the basis of such voluntary statement, a petitioner cannot be convicted. He further contends that though the petitioner has relied on, though the NCB, not petitioner, though the NCB had relied on certain CDR involving two phone numbers which alleged to be used by the petitioner and the other accused. However, such CDR is not a relied material in the such CDR has not been relied by the prosecution while submitting the search sheet. Isn't it? Search sheet. Full stop. Per contra, Mr. SC Kyle, relying on the decision of what bolo?
We also filed our objection also.
Submits that the petitioner is an accomplice to a bigger accomplice to the prime accused from whose possession the contraband has been recovered. Full stop. Contraband has been recovered, and all the co-accused had disclosed involvement of the petitioner. Full stop. As regards the relying on the decision of a coordinate bench in the case of Aminul Islam versus Union of India, reported in 2022-0 Supreme within bracket Guwahati 321. Mr. Kyle submits that contains that in terms of section 133 of the Evidence Act, an accomplice shall be a competent witness against an co-accused person, and therefore conviction cannot be illegal merely because it proceeds upon uncorroborated testimony of an accomplice, and therefore only on the ground that the petitioner is solicited on the basis of the statement of accomplice, a bail cannot be granted. Full stop. Okay. I have given anxious considerations to the submissions advanced by the learned counsel for the parties. Also peruse the material available on record, including the final complaint offense report and the testimonies so far recorded of the witnesses. Testimonies of the witnesses so far recorded. Full stop. In the case of Tufan Singh, Supra, the Honorable Apex Court has laid down a proposition of law that a statement recorded under section 167 of
Only
67 of the NDPS Act cannot be a sole ground for conviction of a person as accused, inasmuch as it is not an admissible evidence, inadmissible evidence. Full stop.
Section 25.
Inevitable, comma, full stop. Subsequently, the Honorable Apex Court, in the case of State versus Pallulabid Ahmed Arimutta, reported in 2020-12 SCC 633, held that the value of confessional statement recorded under section 67 of the NDPS Act, comma, shall remain inadmissible even at the stage of consideration of the bail. Full stop. Comma, bail. Full stop. Now, coming to the case in hand, from the offense report, it is seen that as per the voluntary statement of the prime accused Ranjit Singh, from whom the narcotics were recovered, it is clear the accused is being treated as accomplice. Full stop. The state, according to the prosecution, NCB, not prosecution, according to the NCB, arrested accused Ranjit Singh has disclosed in his voluntary statement that the present petitioner provided the truck to him for trafficking the narcotics. Full stop. According to the NCB, the present petitioner in his voluntary statement admitted that he was involved in trafficking the alleged codeine-based fancy drill of syrup for monetary benefit, and that he has been paid 1 lakh by one Mithun Ghosh through Ranjit Singh for trafficking the said narcotics. Full stop. In this regard, to bring the charges against the bring home the charges against the petitioner, the NCB in its final complaint had relied on certain CDR of mobile two mobile numbers during the period from 1/10/2022 to 1/1/2023 used by the petitioner, and it was found that he was in conversation with Ranjit Singh and Ranjit Singh for 108 times. He called Ranjit Singh for 108 times, and Pramod, is it not? 108 times and 11 times respectively. Full stop. It is true that the CDR is not being relied upon by the NCB. Full stop. In view of the aforesaid, okay. CDR is not relied upon by the NCB, and the material against the petitioner is only the voluntary statement of a co-accused as well as the voluntary statement of the petition. Full stop. That being the position, in view of the ratio laid down in the case of Pallula bid Ahmad Arimutta, within bracket Supra, that a confessional statement recorded under section 67 of the NDPS Act 1985 will remain inadmissible even at the stage of bail. This court is of the view that on the aforesaid material, it will hardly be possible to convict the petitioner under the offences alleged. Therefore, this court is of the view that the petitioner has been able to satisfy the conditions regard of section 37 of the NDPS Act. That being the position, this court is of the view that the petitioner is entitled for bail. Accordingly, following conditions, stringent conditions, while parting with the record, it is made clear that the observation made in this bail petition is only for the purpose of determination of the present application, and the same should not influence the learned trial court in determining the allegation made against the petitioner during the trial.
We file our objection in this case.
That will be written. Hard Mr. The NCB has also filed an objection, written objection, objecting the prayer of bail. Then his judgment relying on all this. Sir Kotoki, you may take some time in correcting. Okay.
Another one leftover matter 54 you mentioned. But in this case, a bail application of another accused was considered by court number 18 also.
Okay.
So it may be placed before that.
We'll adjourn it simply. You make it. What is the stage in that case?
That has been rejected.
Rejected.
No.
So we'll adjourn it. Bring that order.
It is with me, Lordship.
This is a fresh case and Lordship.
We'll call for the scan copies. That's all.
Huh? Lordship, as per judgment of the Honorable Supreme Court, it is to be considered by the same court.
So okay, it is submitted that a co-accused has already been co-accused,
Co-accused approached this Honorable Court.
That one co-accused has already approached this court seeking bail, which has been rejected. Seeking bail in BA
number 4672/2023.
BA number 4672/23. /23. Full stop. /23. In that view of the matter, the registry
May I please, Lordship?
and same has been rejected.
In that case, Lordship, the matter is slightly different, Lordship, because I was the owner. I'm the owner.
It is arising out of same case.
Yes,
Same case, but
Then
Lordship,
when it is same case, it will go to the same bench. This is the principle laid down by Supreme Court.
Yes.
In view of that, the registry may place this case before the appropriate bench. NDPS of Yes, next case.
Lordship, on the last occasion, I prayed for some time to serve notice, Lordship, on the informant. That has been done, Lordship. The IO has sent me the service of notice.
Okay, that is, yeah, this.
Yes.
Just give a print. Can you give me a
Yes, Lord, yes, I will
give me a
submit.
print. You will just keep it in record. Hard, Mr.
269 days.
MU Mahmood, learned counsel for the petitioner. Full stop. Mr. B. Sharma, learned additional public prosecutor, submits that the IO concerned has duly served the notice upon the respondent number 2. Respondent number 2. And a proof thereof has been sent to him in WhatsApp.
Yes.
A copy of the
I will furnish.
printout is kept on record. Just give a printout. The present application is filed under section 439 CrPC, seeking bail seeking bail for the petitioner, namely Nekibur Rahman alias Nekibur, who is in custody pending trial of POCSO case number 318/2023 arising out of Mayong PS case number 43/2023 under section 376/366 within bracket A IPC, read with section 6 of the POCSO Act. Full stop. The trial is pending presently before the
Special Judge Morigaon.
Special Judge within bracket POCSO Morigaon. Where is that scan copies? Scan copies. Where is the FIR, Mr. Mahmood?
FIR page 10, my lord. And the victim and her father and other 2 witnesses have been already examined.
Full stop. This court earlier called for the scan copies of the record, including the statements of the deposition of the witnesses already recorded. Full stop. What is your ground, Mr.
My lord, may kindly see page 37.
Page
Of
37.
the petition, yes. Page 37, the victim girl says clearly that, kindly see page 37 bottom, the accused did not commit any incident with me on the date of accident or incident. So this is a clear statement.
He has been declared hostile, Lordship.
Full stop.
But that is not enough.
The deposition of PW1 discloses that that according to the victim, though stated that she has been taken by the accused in a vehicle and alleged that she was raped by the petitioner. However, in her cross-examination, she specifically stated that accused did not commit rape on her on the date of incident, and that she is also not aware for why the case has been lost. She was also declared hostile and was cross-examined by the prosecution. In her cross-examination by prosecution, she reaffirmed that no incident and stated by her before the magistrate has taken place. Stop. Record also reveals that in her in her statements under section 164, she has alleged the rape. Considering the stand of the victim at different stand of the victim at different stages of the prosecution, this court is of the view that the petitioner has been able to make out a case for grant of bail. The in as much as the victim as well as informant has already been examined, cross-examined, and examined and cross-examined. Accordingly, the present bail application stands allowed 25,000 to the satisfaction of Special Judge POCSO, Morigaon, and all the conditions. Initially, we thought that that is a wrong, maybe wrong in recording, but ultimately it's in seriously.
Medical also valid in maker. No, nothing is there in medical.
61. Well, the same case that has been fixed on Malat 5.
5.
CD notice maybe.
Lordship, your Lordship, Gitanagar PS, your Lordship, FIR is page number 8.
CD notice. Item number 55, Malad. CD notice.
Item, this is item 50?
This is 61.
Yes, Lordship.
55 always CD notice.
FIR, your Lordship, page number 8. And I have filed this petition for 1 Kilwar Ali and Taizul Islam. And in this case, your Lordship, namely.
This case, sending bikes to Bangladesh. Huh?
No, Lordship. Namely one, kindly go to FIR, your Lordship, page 8. Namely one.
Oh, this, EMI.
Yes, Lordship. Tikenjit Boro, he has taken the some Aadhaar card, PAN card from the informant for purchasing one bike.
Who are you? You are Kilwar Ali. What was the item number? 55.
61.
This is 61. Earlier one is 55. CD not received because of the fiction 56. So
we are not a FIR and accused person, your Lordship. And
who are you? Where is your forwarding?
Page 15.
Page 15.
Yes, this is Bangladesh and Meghalaya. What are you saying? No.
Next.
You got me confused. See, you are not aware. Have you read this forwarding report?
16.3.
Huh?
Ground number.
Have you read this? They make certain soft targets. EMI is very easy, no problem. And we can grant you bail. That's why I'm asking which Bangladesh. Now bikes are sent to Bangladesh.
But
have you not read the forwarding report?
But in this case, Lordship.
No,
the
no,
section-
answer my question first.
Yes, Lordship.
I said that this relates to sending the bikes to Bangladesh. You said no.
Reselling to motorcycle, my lord, Bangladesh. There's a gang, my lord, so
When?
already fiction,
Huh?
that is 5-6.
5-6.
Lordship, 420 and 406 IPC raised that, but 420.
It, this matter requires further investigation.
Other section में क्या मतलब सीधी मतलब
He lodged an FIR. His grievance is different, but police during investigation found not only this bike,
that's
hundreds of bikes in this manner, and these bikes are new bikes. EMI they will not give and they will send it to the Bangladesh. Become prepared to this court.
But Lordship, in the
No, but next case.
much of love.
May I please, Your Lordship?
Yes.
Minor 438 application, my lord.
Mm.
The petitioner was granted interim protection, my lord.
Where is the FIR?
My lord, page 11, my lord.
Page?
Page 11, my lord. My lord,
Page,
this is a mail, my lord. What happened, my lord? In this case, my lord,
page 11, yes.
Page 11 and Annexure 1.
Nectar
Yes.
1.
What is this offense?
My lord, here in this case, my lord, this is again a new techniques of committing fraud, my lord, actually.
What is it?
My lord, here, my lord, complainant is a educational my lord, consultant of the my lord, Coimbatore, Tamil Nadu. My lord, the present accused person, they introduced themselves as a consulting agency of Jorhat, my lord. Thereafter, my lord, they promised the my lord agency of my lord Coimbatore that they will admit 188 students of Northeast Assam to their my lord various institute of Coimbatore. And in that regard, some discussion was also held between the my lord complainant and the present accused persons. And during that my lord discussion, my lord, they promised the present accused person that they will admit 188 students of my lord Northeast Assam to the various institutes. And thereafter, my lord, during that discussion, as per their my lord instruction, my
So
lord,
they gave all this mark sheet and
yes.
they gave their commission.
Commission, yes.
10 lakhs.
Yes, 10
Now
lakhs.
subsequently it found that these are not the
Yes.
documents.
Yes, my lord. And some of the my lord name of the some persons phone numbers also available in the FIR. But during investigation, here my lord in the FIR one bank account number is also available. That address is of Jorhat. Thereafter, my lord, during investigation, police came to know that there is no such firm in the name of my lord that consulting agency in
Now
Jorhat.
who is he?
But he is a person from my lord. Later on, police came to know from the bank statement that Abdul Hamid is the my lord. He is the owner of that bank account. And thereafter, my lord, he is a person from Karimganj. That Assam Gramin Vikas Bank is of my lord Karimganj branch. Thereafter, my lord, the detailed banks that statement also collected. And my lord, the
What is
allegation.
his role in the fraud?
His role in the fraud that because by using his bank account, my lord, all other person, his statement is also available in the case there. Now what
He has he's getting the commission from them for giving his bank account.
His statement, the present accused person statement.
My lord, as per the instruction, my lord, the present accused petitioner, he worked as an office boy in the said career today consultancy office.
And
my
the
lord.
name of the firm
Now,
is
my lord-
also, my lord, collected from the, my lord, that bank
What,
statement.
what happened to the other?
Other persons, my lord, regarding the case diary, my lord, there is no such, my lord, phone numbers, mobile, till now, police has not
Has he
collected.
disclosed anybody during
Uh,
statement?
my lord,
You
there-
say you are a boy. You are a peon, say kind of thing. In under whom?
My lord, that accused number, my lord, Gautam Roy, my lord.
Your
Now, what
lordship,
about Gautam Roy?
those persons, my lord, statement is not available. Police till now, my lord, police
They have
could
not been
find out
arrested.
all those persons, my lord. Your lordship may kindly.
They want
produce-
him to first get the bail.
Yes.
Then they will come, we are accused similar.
My lord,
Your
So-
lordship may kindly first peruse his statement, Abdul Hamid, the present accused statement, what he states.
My lord, now I have made an agreement with the informant, my lord, and I have annexed a copy of this agreement, and I have also returned the amount, my lord.
Where is your agreement?
Page 25.
Huh?
Page 25.
These are, my lord, new techniques, new methods, my lord, of committing fraud, my lord.
Today is
24th of May, my lord.
24th of May. What is your status of payment?
My lord, as per my instruction, my lord, 2 installment has been paid, my lord.
So next is due.
My lord.
My lord, this FIR is of 2017.
My
And
lord,
that is a
No, agreement is entered on 26th.
2020.
The learned counsel for the petitioner
lord.
submits that though there was an allegation of defrauding the informant to the tune of rupees 10,40,250. However, the petitioner has entered into an agreement with the informant to repay the entire amount by 26th of
February.
May
Well.
2024. And accordingly, the learned counsel for the petitioner submits that he may be granted a week's time to file an additional affidavit
Yes.
to show that he has paid the amount in terms of the agreement within bracket annexer 6 entered between the informant and the petitioner.
My lord, here in page number 27, I have annexed the deposit slip of first installment.
That we do not know.
my
Because
lord-
by 26 May, you will have to complete.
My lord, my lord, kindly peruse the
Your
annexure 5.
statement, we are doubtful. One
lord-
time, one day you will say, I am a daily labor, some
Yes,
person from Bihar has come and given my account number is taken. Now you are saying that 10 lakhs rupees you will return. Why should you return then?
Suppose, my lord, they now will return that amount to that agency, my lord.
My lord,
My lord, in respect
We'll-
of how
we'll
many
consider-
agencies, my lord, he is.
We'll consider.
here, my lord, kindly peruse.
Or you
the-
want a rejection right now?
No, my submission is that, my lord, the case was registered in the year 2024 only, my lord. Not in 2017, my lord. Kindly peruse annexure 5, page 20, my lord.
That we have said 20, when we have said 27?
No, my lord, the FIR was lost in the year 2017.
Ah.
That is registered, my lord, on
Now
61.
what is your ground then? Why are you saying that?
My lord, I was charged by the police in the year 2024 only.
No, that we understand. Your whole case is that I have want to give this money back. Isn't it? So therefore, we are adjourning this matter. Or you want that in view of that modus operandi, you are part of this gang, let us reject this petition. Which option you want?
Some time may be given, my lord. I will file an additional affidavit.
File an additional. If you want that, no, on the basis of case diary, we should take a decision. We can take a decision right now. As Mr. Bothakur wants.
Yes.
Isn't it?
Yes, my lord. Because these are my lord, new techniques of committing fraud. My lord, with how many students, my lord, maybe, my lord.
Case diary be, for the time being, case diary be returned back to Mr. Bothakur.
My lord, may I pray for the extension of the interim order?
Interim order partial shall continue. List this matter on 4th of June.
Hi, Lord.
Yes.
Page 438 application, Lordship.
FIR.
FIR is at page 14, Lordship.
Page 14. Any interim?
Yes, interim is there.
Statement recorded.
APR statement recorded, my lord.
Bothakur, you need them?
No, my lord, otherwise.
No.
No.
Or Mr. B. Haldar,
B. Haldar.
learned counsel for the petitioner, and also Mr. Bothakur, learned additional public prosecutor. Apprehending arrest in connection with Fatasi Lambari PS case number 82/2024, under section 420/406/468/471 IPC, the present application under section 438 of the Code of Criminal Procedure 1973 is preferred by the applicant, namely Sri Debojit Chanda. Full stop. The aforesaid case has been registered on the basis of an FIR lodged by one Sri Pradyut Kumar Chaudhuri, the allegation made in the FIR is to the effect that the informant entered into an agreement with the applicant for construction of a multi-storied building, and while applying for permission, the applicant has enclosed some documents containing signature of the informant, and the said signature of the informant were not genuine and forged by the present applicant. This court, under its order dated 14/3/2024, while calling for the case diary, granted interim protection from arrest to the petitioner. The case diary is produced. Perusal of the case diary discloses that the investigation has substantially been progressed. The petitioner has got his statement recorded. The petitioner has also been cooperating with the investigating authority. That being the position, considering the material so far collected, and also considering the fact that the petitioner has been cooperating with the investigating authority, this court is of the view that no custodial interrogation shall be required for further investigation. Accordingly, the present application stands allowed, and the interim order made on such and such date, interim order passed on such and such date is made absolute with the same terms and conditions.
Charge submitted, my lord.
Any interim?
Yes, I'm on interim, Your Lordship.
Earlier interim was there. Yes. CS number 26/24 dated 3/04/24.
It is submitted by Mr. Parasar Larnes, additional public prosecutor, that after completion of the investigation in Behali PS case number 24/2024, registered under section 365/34 of IPC, the investigating officer has already submitted charge sheet, being charge sheet number
26/24 dated 3/04/24.
Okay, full stop. In view of the aforesaid, the present application stands closed. Full stop. The interim order passed earlier on 8/4/2024 shall continue till the petitioner appears before the trial court and appears before the trial court on receipt of summon, summon, full stop. Summon, full stop. The petitioner shall be at liberty to seek a regular bail before the learned trial court after his appearance on receipt of summon and on filing of such application. The learned trial court shall consider the same and pass appropriate orders in accordance with law.
34, sorry, my lord, CD not received.
Any interim?
Yes, ma'am.
When?
CD Hosai Malad on 7th of June. Malad.
CD likhi CD not received. Interim to continue.
Man.
List this matter.
7th of June.
35.
Yes.
CD receiving.
Same.
238 application, madam.
CD
is not
received. CD received.
Okay. What is the FIR?
Authorized page-
Any interim?
No,
What is the FIR?
page number 8, madam.
8.
Yes, madam.
Tablet is recovered. Is there not received?
Okay, there is
Yes,
no,
that
tablet
tablet is recovered.
not recovered, and my lord, one of the my lord, home guard, two home guard are there, my lord. Other my lord, given statement that yes, he gave me 1,000. He took my lord, 2,000 and subsequently given me 1,000. But he's my lord.
This FIR has been filed out of my lord, here, my lord. He has been restrained from going inside. And this
That's true, but
government ballot, he
was restrained from going what?
Inside the ISBT because he was carrying, admittedly in the FIR itself, he has written that he is carrying alcohol mixed water, my lord.
Okay, that up to that fine. You show the bottle.
Yes. My lord, and the co-accused has been arrested and he has been granted.
You also go there with your friends and come back, will grant you bail.
as per a co-accused statement also, my lord,
Or you people are not in peace, not been able to remain in peace. Somebody will go to a bus station, then also you will demand money.
2,000 given.
As per my instruction, my lord, there was no demand. As per my instruction, my lord.
Or somebody will give you 2,000 rupees. Instead, and that also alcohol is not full bottle. It's a mixed up bottle with water. He'll throw that water bottle and go inside. Why should they give you 2,000?
Tablet is as per statement office given by his office. So
There was no tablet, in fact, as per my instruction, my lord. They have searched their bag also because they found that alcohol.
Your partner is arrested.
Understand, granted.
he said that yes, বেগত কি আছে নাজানো কিন্তু মোক ই 1,000 টাকা দিছে।
And I am ready to, my lord, cooperate with the home guard, my lord.
What will you cooperate?
মানে we don't expect some home guard and policemen
That is
because
the
of
difficulty.
otherwise
Otherwise, if it would have
Yes,
been
yes.
other person, I would not
Yes.
have hesitated to grant him bail right now. But
My lord,
only difficulty is he
some
was a home
departmental
guard.
inquiry is also going on, my lord.
Huh?
Departmental inquiry is also going on.
I think
What departmental inquiry? You should not
He'll
be,
face the
you should be
consequences, my lord.
discontinued. Your job
Yes,
is
my
to
lord,
seek.
he'll face the consequences regarding that, my lord.
Professor, what you say?
Being a home guard,
He has already faced, my lord, consequences.
Already faced,
He'll face the trial, my lord.
You are kept there for to.
and co-accused, who arrested, he never take the money. Money taken by him. He only get a
And
share.
that is the statement, my lord.
No statement.
There is a ground, my lord, for granting bail.
So statement is also that
Yes, my lord.
you have taken demanded 10,000 and
10,000.
2,000 granted. How can we grant an anticipatory bail in such a case? Tell us.
Tablet not
That is
taken.
the statement of the
Please
accused.
this matter on Monday. I'll think of it.
Item 36.
My senior is on legs. Can it be taken up by 2 lakhs?
Where is the affair? CD is there?
CDG.
Where is the affair? Tell us.
Page number 7.
We'll see whether a senior's presence is required. Parent.
The file is translated for this page 7. Okay.
What are the offenses? Which is senior?
Section 8 of the Assam Category.
264/29. Section 8 of the.
What is the case that it says?
Yes, they don't have any license. They are doing the business since 4 or 5 years ago, and sometimes they throw out this.
Who is this informant?
Informant is a informant is a village person.
Petitioner is not a salary.
As per section 8 of the this act, prohibition of sale beef and
Punishable?
Punishable 3 years extended to 10.
And what about the other?
Extended to 8 years. Extended to 8 years.
268. What is 268 and 429?
Public nuisance. That is illegal. That is illegal.
Then what about 429?
Mischief of killing, yes. I mean, cattle, so this is also available.
Then what is non-available?
The 8th section,
Section is up to
3 to 8 years.
3
Max
to
minimum
8
is
years.
3.
What it says, read it.
Prohibition of sale of beef or any beef products. No person shall directly or indirectly sell or offer any exposed to sell or buy beef or beef products in any form, except the places permitted to do so. So they don't have any permission.
So they are selling beef. Now, where is the offense, prescription of offense under which provision? Read it.
Penalty.
Penalty.
Penalty is section 13. Whoever contravenes any provisions contained in section 4, 5, 6, 7, and 8 shall be guilty of an offense punishable with imprisonment for a term which shall not be less than 3 years and which may be extended to 8 years and with fine, or which shall be less than 3 lakhs rupees or extended by 5 lakhs rupees or both. Matlab,
You
neighboring,
understand,
neighboring
it is
people
not,
also that
it is
one
not,
of this
it is not
waste in the
acceptable.
pond, matlab.
This is not acceptable. That is
Pond,
no
matlab.
doubt about that. You take action against him, but will you need read a custodial interrogation?
Matlab,
That is the one aspect I am thinking. Otherwise, the behavior and the villagers are annoyed.
the villagers are annoyed. Matlab, there photograph also matlab, in the
And
case.
it's
there is
not
matlab.
that it is that some other religion. The informants are belongs to the same religion.
Same religion, because they
is-
thrown out this in pond and all this matlab.
They are selling in that particular that area, Lordship.
But
Same religion.
but other matlab slaughter also.
What
they
is, I am thinking is it a case of custodial interrogation? It's closed down his shop.
That may be, but my one line of.
No, that's that we understand, but ultimately we'll have to make a decision judiciously. His conducts are not good.
He is not a slaughter or past slaughter.
So therefore you cannot do this.
You don't have any license, matlab. They are just
Because case diary says that you have done it. You don't have a license, and that has been made a criminal offense. So then
water is consuming matlab, and that
why it cannot be. The legislation wisdom has formed a legislation. It is now a criminality is given to that.
and throwing the waste in the pond, that is all, though matlab.
Yes, whatsoever. What is your senior? Monday. Any interim?
No.
No.
Monday. You should keep the case diary. On the prayer by learned counsel for the petitioner, matters stands adjourned and be listed on Tuesday.
Seven, sorry, matlab, CD not good.
CD not any interim?
No, my lord.
No interim was there.
When?
No, Lakhimpur. Fifth, matlab.
Fifth.
Till then, interim protection will be running. But his name is not named in the FIR, my lord.
No, we'll see. On the next date, we'll see.
Please, Your Lordship.
Yes.
438 application under the POCSO Act, my lord. Yes, that was available. Notices were also issued, my lord. But I cannot find any office note regarding service, my lord. Service copy I've seen, my lord, but there's no note and there's no signature.
No. You have taken steps in terms of what?
The first order, my lord.
No, that we understand. Following which procedure?
My lord, through the learned PP, my lord. Deepak Naik judgment, my lord.
Deepak judgment. Okay. Mr. Parasar learned counsel for the petitioner submits that he will obtain instruction whether the steps has been taken in terms of the determination made in Deepak Naik versus State of Arunachal Pradesh, and if so, whether notice has been served by the concerned IO. Full stop. Accordingly, he prays for an adjournment for the aforesaid purpose. Full stop. Prayer is allowed. List this matter on. You give anything if you have given to the paper.
There is the
Okay.
record.
Registry. In terms of the registry also update. Put an updated note as regards service. Upon respondent number 2. Fourth.
CD to be retained.
CD is there.
CD is there.
Or you go through the CD if you think that 2 is not necessary.
CD I have gone through, my lord.
There's two issues, my lord is just implying for a moment, my lord. The informant is alleging that.
Okay, let us see. Otherwise, we'll see on the next date. What is the stage of investigation?
Matlab, just her statement.
What is the age of the victim?
11 years.
11.
Her
Her statements are there.
Her statement is available. 164 available.
Okay, so what is the FIR?
FIR, my lord. 13, my lord.
Yes, 13.
13, my lord.
What is your age?
My age, my lord.
40, I think.
I am a school. My age is 54, my lord.
54.
Now, that's the only one thing I would like to point out to your lordship, my lord.
Yes.
There are first FIR is at page 13, which is in which I am seeking bail, my lord.
Okay.
Here the informant is alleging that on the pretext of teaching, since I am a school teacher, teaching her minor daughter I removed her undergarments, my lord, and touched her private part. That is the allegation, my lord, in this FIR. Now, my lord will kindly see.
Just a minute.
164, 161 mother statement. All are.
Just a minute. Okay, then.
Then, my lord will kindly see page number 23, my lord. This is just 1 month prior to the incident. This informant lodges a similar FIR alleging similar allegation against another person, my lord. We have been able to find out these two FIRs, my lord, but apparently there are other FIRs also lodged by this informant, my lord, alleging similar offences in respect of the same victim, my lord. And
This is against whom?
This is against another person, Sultan Ahmed.
What happened to Sultan?
Sultan Ahmed, that we do not have instruction on that part.
And
my
you
lord.
want to say that there are other affairs?
Yes, my lord. As per our
Can you bring?
we try to find out, and we should not find out, my lord. Perhaps if the
What is about these two affairs? Anything?
No, no information regarding this matter because.
Let us see the victims.
No, no.
Okay, you have given. What is the other case number?
Lanka PS 17 and 24.
17 of us. That was lodged on, my lord, 28 to 2024. This was lodged on 23/3/2020. Our contention is that, my lord, there was a relation between this petitioner and the informant, my lord. He was demanding money. When we refused to pay the money, my lord, this FIR was lodged, my lord. This is a modus operandi of the informant, my lord, as per our contention.
No, there may be a victim, victim of at many stages, many things. This cannot be ruled out. It's possible. It's possible. So we'll but in terms of this 11-year girl, her statement is clear.
Clear. 161, 164, both clear.
Clear. 11 years.
Because of that, my lord.
That is what we could find out, my lord, and that is our contention. In this kind of cases, we cannot do much, my lord, also because statements tend to be damaging.
What is the gap between these two incidents?
My lord, less than a month.
Huh?
Less than a month. This was on 28.
Where is the other FIR?
Other FIR, my lord, page 23.
79.
Page 23, my lord. Annexure 5.
That is lodged on 28-2.
28-2.
And this is on
23-3.
This FIR 23 is against you.
23 is against me.
And what is the other?
Page 23, my lord.
28-2.
No, 23, sorry, my lord. 23 is the date, so hence the confusion. Page, the FIR against me is at page 13.
1-3.
1-3, my lord.
$23,300.
We'll reject it.
Going through the statement.
One simple submission, my lord. Since we are submitting that there may be other affairs also on this aspect, my
You
lord.
want some time?
No, my lord, a report, because we could not trace out, my lord. If the IO is able to submit a report, if this informant has lost similar FIRs, my lord, in the last 6 months, my lord, if that can be considered, my lord, then perhaps an inference can be drawn as to whether there may be any veracity in the allegations, my lord. 2, we have shown, my lord. If there are others, my lord, if there is no such report, my lord may reject it, my lord. That perhaps, my lord, can be done.
Where is the statement?
Statement, we have no statement on that effect, my lord, because this is something which we found out subsequently.
File a statement on oral submission. You cannot pass a note. See, Mr. Parasar, it may be an SRL incident. If what he have said is correct continuously in different affairs, that may be an O-ring because this act is also being misused.
Yes,
we are
sir,
not
that
saying.
is-
So balancing the things, I think we'll return back the case diary, let him file a statement.
My lord.
Thereafter, because there is no interim,
Yes, my lord.
no interim. We are not granting any interim. Let the case diary be returned back, or if he can file an
We'll try to find out if there are other FIRs from our end also. We'll again
no,
apply, my lord.
even if you file an FIR by next Monday or Tuesday, we can fix a date with a request to the IO that whether any cases are pending, which it will be.
That I'll take care of, my lord. And regarding, my lord, if another date is fixed, then regarding the service also, my lord, already, my lord.
That's why let the earlier order remain.
Yeah,
Okay.
earlier order it is
In the
fixed.
meantime, last of delay. In the meantime, the petitioner may file additional affidavit. Okay, let us be that only. Ah. And if she comes in this case, it's better. Then we can, if we make a statement, let us say whether correct or not. Let the notice be complete first. Okay, earlier order will remain. Sketch that.
I'm deeply obliged, my lord.
It is 4/6.
4/6, yes. Next.
Yes,
Oh, yes.
deeply obliged.
How many matters are left? 20.
Oh, आगे अपने स्थिति में ही। हाँ, 4/6.
ठीक है, thank you.
My lord, here, my lord, the text are date, my lord. On 29/3, charge sheet has been laid down, my lord.
29/3.
24, charge sheet laid down, my lord.
No. When was he was arrested?
When he was arrested on 11/9/2023.
2023.
Yes, my lord.
So his date of arrest should be counted from forwarded on?
From the yes, my lord. Nowadays from that date, from forward from the date of arrest.
Not from the date of.
Yes, now my lord. It has been
Okay,
changed,
so
my
it is 11/9/2023.
Yes.
Yes, then
Admittedly, my lord, on 8/3, my lord, it came to end, my lord. My lord,
8/3.
yes, 8/3.
2023.
As per my lord, yes.
180 days
Yes, my
over.
lord. Now,
Okay.
his contention is that, my lord, he is entitled for, my lord, default bill, my lord.
Okay.
But now, my lord, what, my lord, as per the learned Apex code and the decision so far, my lord, the law is that, my lord, before Chalan, the right to, my lord, before the CS, my lord, the right to default bill, my lord, it subsists, my lord. But once the, my lord, CS has been filed, my lord, now the question of default bill, my lord, does not arise, my lord. And how this can be, my lord, ascertained, my lord? If he has any bail application pending.
That is correct.
Before the filing of charge sheet, my lord. Now, my lord, in this case, there is no bail application pending, my lord, before the charge sheet is laid down, my lord.
Okay.
So once the, my lord, as per the, my lord, M. Robinson's judgment, my lord, once the charge sheet filed, my lord, the bail will has to be considered as per the merit of the case.
So your case, your contention is that on 8/3/2023, no bail application was pending.
Yes.
So since no bail application was pending, so filing of charge sheet on which date?
filing search sheet on, my lord, 29/3, my lord.
29/3.
Yes, till then, my lord, there is no bail application either showing that he wants to be of,
So
he
since
wants to-
no bail application on
Yes.
8/3 was pending, so
Pending.
therefore he
Yes.
will not be entitled for
And then-
default once search sheet is filed.
Yes, Francis, that is the law as per, my lord.
Yes.
May I just take the, my lord,
That
that is
citation?
citation, my lord, 2021 2 SCC. It is page number I am giving, my lord. My lord, 485, my lord.
485. Can you
Yes.
give it?
And my lord, the paragraph is, my lord, 18.1 and 18.3, my lord. May I pass on this book, my lord?
Yes.
2 SCC. 485. 18.1, my lord, Muslim kindly. What is the, my lord, indispensable right?
Paragraph 18 point?
18.1, my lord. Left, in the left page, my lord, is in the below, my lord. Now, my lord, the question was whether the right avails of that, my lord, meaning has been, my lord, cleared by in 18.3, my lord, paragraph. Application আছে জানো? Application
Yes.
আছে জানো?
Yes.
Eight,
I
my-
can see the my lord, the page 18, my lord. On that day itself, application filed, it was rejected. Page 18 order passed by learned, my lord, same.
Right,
Quote
right.
below, page 18.
Where is your petition 1032?
1032.
Where is that petition? Copy of the petition.
That has not been annexed, my lord. That
That is vital. That is the
the
where.
record is available, my father. Here, my.
No, my lord, it is not there.
Huh?
Not there in the record, my lord.
Because when this 1032 was filed, it was decided on 11/3. If it was pending on any other date prior to 8, if it was filed, then he will have a right on that date.
Yes.
Isn't it?
Yes, that is there.
So therefore, that is a vital document
Yes.
for you.
Mm.
What was the date of that application? Suppose you filed this application on 11/3 and it was rejected, or 9/3, it was rejected on the 11/3. Whether on 8 any application was pending
And
for
also,
bail.
my lord, there in the order also states that, my lord, an application for extension has also been filed, my lord.
No, that will be another aspect.
Yeah, whether it is before or not, my lord.
That is also very important.
Yes, that is all. If
When it was filed and when he was put to notice,
Yes.
only filing will not do.
Yes.
And there are judgments where it is said that if you file on the last date, you cannot expect for a notice.
Yes.
If you file an application on 8/3 for extension
Yes.
or 7/3 for extension.
Yes.
Because
Because-
law is well settled that the notice is to be given to the accused for extension.
Yes, yes, that is there.
So if you file it on 8, how a notice will be given? Hey, Moise, I have given a judgment in Nagaland, Kohima. Extension of last. When extension can be granted. Yes, what do you say?
So, Honorable Satyendra Kumar until it is 2022 10 SCC. It says, my lord, section 167(2) provides for clear mandate. The investigating agency must collect relevant, my lord, required evidence
These
within.
are not the
That
case.
is not the issue.
This is not
Issue
the issue.
here is that search sheet was admittedly filed. Had no search sheet been filed, there would not have any debate.
Not. There would not be
Okay,
any-
there would not have any debate.
Yes.
Now, search sheet was filed on
29/3.
29/3/2023, admittedly beyond the statutory period, is not it?
Yes.
And statutory period was admittedly over on 8/3/2023. Whether on 8/3/2023 a bail application was pending, that is the issue.
That is the main issue.
Because Sanjay Datta and subsequently Hitendra Vishnu Thakur, Sanjay Datta, and subsequently that has been clarified, saying that there should be a pending application.
Also, in
Rakesh
bench,
Go ahead.
it has been there from M. Ravindran.
So your bail was rejected on 11/3. If it was filed on 10th, if it was filed on 9th, even 9th. No, he's correct. Because it was pending on 11/3.
Yes, 11/3.
First, it was filed on 29/3.
29/3.
Then
no, that is what I am saying. Because the one application has also been pending, my lord. When this application has been filed for extension, that is
no. On 11/3,
Yes.
his bail was wrongly rejected, meaning thereby. On 11/3, meaning there on 8/3,
Yes.
time was over. On 11/3, he
Yes.
filed a bail application.
And the-
Already he was entitled for default bail.
Yes.
Only praying for extension will not give that.
That is my that date when it was filed is not in the
No, now this date is not important.
order, my lord. Because it might have been, my lord, your lordship can see the my lord,
No, whatsoever
order.
is happened on 29/3/2023. On 8/3/2023, 180 days was over.
Not it.
Okay. Search sheet was not filed.
Not.
This indefeasible right will
Yes.
go pendency will
Yes.
require only when search sheet is submitted. Isn't it?
Yes, yes. Yes.
So admittedly on 11/3/2024, when his bail was rejected, no application, no search sheet was filed. Then what is the ground of rejection?
My lord,
Then, my lord, according to the says, my lord,
there is an
according-
application for extension. That is the
Application of extension law is well settled. What is the law in regard application of extension?
notice.
Huh? Notice.
Notice is there.
So
My
it should be filed prior to 8/3 when it was filed.
That is what my
11/3.
that is not
11/3.
So if that has been filed beyond 11/3.
Extension filed by the investigating officer, page 20.
Mr. Goswami, do you understand?
Yes, yes.
When the extension was filed, if it is filed beyond the statutory period and on the date of 8/3 or beyond 8/3,
Yes.
before filing search sheet and application was filed, he had already indefeasible right.
Yes.
Isn't it?
Yes, that is there.
Monday,
Monday.
be clear
Because,
about
sir,
it.
because only thing that is the fact, my lord. Other this person will my lord, from the record if there is
You just
anything
go
else.
through the
Because I have
phlegmatic.
not found, my lord.
No, now these are not important things. If these facts are correct, if
Yes.
you do not dispute this,
Yes.
he was arrested on
Only
11/9/20
dates, my lord.
2023. No problem on
Yes,
that.
yes.
180 days was over on 8/3/2023.
Yes.
On 8/3, no search sheet was filed.
No.
Whether an application was pending or not pending is irrelevant for the time being, because he preferred, admittedly a bail application was pending on 11/3/2024, which
No.
was rejected.
No.
On what count? That
No.
was rejected on the ground that already an application was filed.
Yes.
Application was filed on which date?
11/3.
11.
Monday.
So this was filed beyond 8/3, 11/3. We'll pass this
Right.
order.
Monday, my lord.
Monday? Okay. Mr. Goswami Learned Counsel submits that he may be granted, matter may be listed on Monday next, that is date to divorce, so, on which date he will go through, he will address this court on the basis of the scan copies received from the. I think this is a clear case of grant of bail. That's
application date.
and that there it is judgment to lay low.
56.
Yes. Anything received, Mr. Goswami? Case number?
CD
One-
not received, madam.
Huh? No, not CD. This was, we asked for a report.
Oh, this.
This
Yes,
was,
madam, the case has been registered, madam.
give the name number.
Yes, I'll give.
It is submitted by Mr. MP Goswami that a case being
The Rota PS case number 54/24
54/24
under
under section
section 120B,
120B
420, 406, 468.
has been registered. Full stop. In view of aforesaid submission, the learned counsel for the petitioner submits the heat may be granted a week's time, week's time to bring on record the aforesaid FIR by way of an additional
Well,
affidavit.
In the meantime, my lord, CD may be called for, my lord.
Prayer is allowed. Call for the case diary of Rota PS case number so and so.
54,
Submit one thing, my lord.
54/24.
Yes, my lord, this section are, my lord, below, my lord, 7 years, my lord.
That's why that's why I was proposing that we'll adjourn it so that we can at least see the FIR.
My lord.
Isn't it? That's why I said we'll list this matter after we want to see the FIR for consideration of an interim. If you want an interim, we want to go through the FIR. And
Let
if
me
you
take
say
that
that no, let me file in the meantime, let the case diary.
Let the case diary be.
Okay. That orders. Okay, fine.
Yeah.
On?
On my lord, from Rota. No. On 7th, my lord.
7th.
7th of June.
7th of June.
In the meantime, you file, you bring.
My lord. Okay.
Yes, sir.
May it please your lordship.
CD is there.
And CD is not there, my lord.
Any interim?
Lordship,
Oh.
Lordship, they kindly reappreciate the fact once again, Lordship. Appreciate the fact,
Yes, my
Lordship.
lord.
My
Two CDs
affair
are
is
called for, my
Lordship,
lord.
my affair is at page 57 and at the intervention of the
Police station.
Sonapur.
Sonapur PS.
Sonapur. Next week, give a date. Well, then we others will consider on that
Yeah.
interim. Okay.
20. On my lord, 3rd, my lord, 3rd of
Third.
June.
Obliged.
Yes, case
May
diary
it
is
please
there.
your lordship. Case
Yes,
diary was
it is.
called.
Yeah. Where is the FIR?
FIR is at page number 12, your lordship.
Who are you?
Lordship, I am an employee of the railway, your lordship. I have annexed my ID card also at page number 10. I work as an assistant PL/AC, your lordship. My work is to manage the train lightning and AC.
Just a minute.
Lordship.
You are what is your Ansari?
Hello.
You are Gautam Burun.
Lordship.
Yes, you are a railway officer. You are not happy with your salary or what?
Lordship, actually, I was released in the FIR just because I was the duty officer at that point of time, Your Lordship. I work in a shift basis, Your Lordship. And at that point of time, when the search was there, I was the duty officer. I handed over my I-card and my phone number to the concerned officer also in order to cooperate also. Later on, I found that my name has been released in the FIR, Your Lordship. And any consignment.
What is the case there?
Chief, only thing, Lordship, he allowed the goods to be carried in that car, Lordship. That is unauthorized, Lordship. And in the meantime, report has been called from the food analyst.
No, that is not very important.
So
Vital nut is
yes.
not very important, but a railway officer, this could have been drugs also.
Yes, that is what, Lordship.
It's an unauthorized, illegally carrying certain things in the cabin or in the official. It's difficult.
Lordship, and
Now, Lordship, he has been asked to appear before the concerned authority, but he has not appeared, Lordship.
Is he having interim order?
No.
Okay, we are granting you interim and appear, then we will return back the case diary and see what is what actually. Considering case diary produced, considering the material available, so considering the material so far collected by the IO, this court is of the view that statement of the accused shall be recorded and is also further viewed that at this stage custodial interrogation of the petitioner may not be necessary. Accordingly, as an interim, it is provided. Case diary be returned back. Full stop. You appear within 10 days. Baki conditions given, following conditions, 10 days and all. Case diary be returned back,
Lordship.
And be produced once again.
The Lordship is granting 10 days time.
I am giving 10 days time.
Then Lordship, 13/6.
13/6.
final production is
May it please your Lordship.
Yes, where is the
Lordship,
FIR?
this is a 439 bail application.
Where is the
Lordship.
FIR?
Page 16, Lordship.
Case?
Page 16, 16, Lordship. Date of the FIR can be taken into. Iron manhole cover was missing, stolen, Lordship. Now, Lordship, kindly come to page 17, Lordship. Forwarding report that is on 21/5, Lordship. Ground of arrest, Lordship, kindly see. Ground of arrest number 2, 134 numbers of iron rod, not manhole cover, Lordship.
And where is the co-accused?
Now, Lordship, 41 notice was not issued, Lordship. 379, Lordship, offense, Lordship, 41 notice was not issued, Lordship.
Oh, forget about that. Where is your co-accused?
Co-accused, that is page 19, Lordship.
That is forwarding report of other co-accused.
Co-accused, Lordship.
Yes.
Page 19.
19.
19.
This is forwarding report.
Yes, Lordship.
No, where is your bail of the co-accused? Order of
Yes,
bail.
Lordship. That, Lordship, will find on page 25, Lordship. Lordship, the recovered, may I place the Lordship scissor list, Lordship, that recovered from the Binod Borua. It is recovered from Binod Borua, Lordship. Another, the trust. Not this petitioner. This petitioner is a scrap dealer, Lordship, having, Lordship, trade license, Lordship. I have all annex, Lordship. Trade license certificate, Lordship.
Stolen scrap also. Scrap can be stolen also.
That, Lordship,
No,
I have
those are made
Lordship,
of
I have
iron.
not purchased.
Don't say all these things.
Yes, Lordship, I have not purchased, Lordship. What happened there, Lordship? Can I see, Lordship? I have a scrap dealer's, Lordship, that registered from, Lordship, there.
Those are manhole cover.
Let me submit. Then they said, Lordship, it is 134 was recovered from this, Lordship, Binod Borua, not from this petitioner, Lordship.
And that the Vinod Burua arrested lordship 1334 lordship.
Where is Vinod Bora's bail?
Vinod Burua lordship, Debojit's bail was considered lordship.
Yes, sir. What you say?
Will be required because my lord 143 numbers as per from the forwarding report, those are manhole covers my lord from the.
From him, it is some rods were
But
recovered.
here from the
So ask which one page, Mr. Botako?
Jalukbari PS.
No, which page you want to see me?
My lord, page 17 is the forwarding report.
Of this person?
Yes.
Page 17?
Page 17.
Yes, lord.
Zakir Ali.
Zakir Ali. And my lord, next page 18, my lord, he is also a habitual offender.
That 413 is not their lordship. Case was registered under 411 lordship, 379 lordship. 134 number of iron rod.
Where do we get iron rod?
Lordship on ground of arrest lordship, number 2 lordship in page 17 lordship.
Okay.
Bottom lordship.
Sir, used for my lord.
Iron rod lordship. They
construction of
said in
those
as
manhole
per
cover.
FIR lordship, it is manhole cover lordship.
14 numbers of manhole cover and 4 numbers of
Manhole
iron-
cover, that was not recovered from this petitioner. And if it is recovered lordship from Vinod Bado, that on first.
Okay, let us have it on Tuesday.
Yes, sir, on Tuesday.
From Jalukbari.
Yes.
Hello.
CD. Tuesday.
The CD was called for. My lord.
Yes.
Received lordship.
Where is the FIR?
FIR is at page 13, vernacular, my lord. We are the directors of.
Any interim?
My lord, we are on it.
Do you want them? No.
Because all the activities is done by the manager of the PSF.
You don't want.
He did not. They have nothing to do.
Here is the case then. Full stop. The material so far collected by the investigating officer, in the considered opinion of this court, do not warrant custodial interrogation of the petitioner, inasmuch as the petitioner has cooperated with the investigating officer and the investigating officer had also recorded his statement. Interim order made absolute. Yes.
May I please, Lord? My lord,
Yes.
this is for 38 application, my lord. Offense committed in
Where is
West
the
Bengal,
FIR?
my lord.
FIR.
FI is page number 23, my lord, additional affidavit, my lord. My lord, similar kind of cases, my lord. Lordship pass order, my lord. My lord, till till appearance, I may be protected, my lord. 41 a notice issued, my lord. I will appear before the investigation agency. Similar kind of cases, my lord. My lordship has.
CD is there?
No, my lord, CD was not called for, my lord. This offense committed at West Bengal, my lord.
Now what do you want?
My lord, 41 a notice issued me, my lord. I will appear before the investigation agency. Till then, my lord, I may be protected till appearance, my lord. Only for 10 days protection may be given.
This is same case or what?
Not same case, similar type of case.
Okay, appear.
My lord. Similar.
Sector দ্বারা
Disposal.
Highly please.
15 days, let them go and appear.
Highly.
In that case, my name is SCGC. SCGC.
FIR is page 17 lordships. Subsidiary matter lordships. Page 7 is the FIR lordships. Subsidiary matter lordships. Also was
7, substituted.
Yes, page 17 lordships. One second.
What is a translated copy? It's not legible.
Lordship.
The 164 is there in the LCR, I have flag mark. 164 is there.
Let us
But,
paste 12.
after 6 month affair, medical she refused.
Yes, Lordship.
Let us see. Elsewhere. Okay.
Medical she refused.
That too, Lordship, after filing my complaint, Lordship.
And the complaint story is also same. He filed a complaint that, and this story is same story, almost. Defamation.
Where was your case?
Lordship. What is page
19.
Yes, page 19 is the English version, translation copy. Page 28 is the warrant, Lordship.
Just a minute. Page?
Page 28 is the warning, Lordship.
What is the stage?
Appearance Lordship. NPW was issued on the first date, Lordship, and your Lordship suspended that NPW. So, my Lord, that matter is pending for appearance, Lordship. Last occasion, Lordship suspended the NPW.
Hard.
Hard.
Most learned counsel for repetition. Also hard. Mr. Parasar learned the original publication. The present application is filed under section 438 CrPC by the petitioner, namely Swenso case can The informant filed a complaint petition before the court of Chief Judicial Magistrate Dorong Mongoldwe against one Sabitri Rajbangshi, inter alia, alleging that said Sabitri Rajbangshi has spread a false news that the petitioner raped her. Full stop. On the basis of such application, what happened to this application?
Case was registered, lordships.
Where is
That
the
is
registration?
CR number 17 and 23.
Said case was registered as CR number 79 of 2023.
Lordships.
It's pending now.
Lordships.
Okay. The same is pending for pending before the learned Chief Judicial Magistrate as at present. Full stop. Thereafter, thereafter said Sabitri Rajbangshi on when?
Lordships.
On
15/7/23, lordships. That is below lordships.
on 15/7/2023 lodged on FIR, isn't it?
Yes, sir, FIR.
FIR before the
Page 17.
officer in charge of before the
Superintendent police, lordships.
Superintendent of Police Dorong, inter alia alleging that the informant attempted to rape, isn't it? No rape. Raped, no?
Not attempted, my lord.
Rape.
Rape.
Okay. Alleged, কি করলো? Entirely alleging that she has been raped by the present petitioner. Full stop. The aforesaid case was registered as
Sipazar PS case.
Sipazar PS case number 272/2023 under section 376 within bracket I/109/50 IPC. Full stop. The investigating officer, after completion of the search sheet, file search sheet. And you approached this court earlier by filing bail. What is these orders? Altaf Hussain. What are these orders annexed? Page 49.
That is page 49. These are some similar situations that are hyper. I'm sorry, lordships.
Equation.
Sashid on
Sit.
30823.
23. Full stop. Now the petitioner has approached this court apprehending arrest in this case, in as much as already non-bailable warrant of arrest has been issued by the learned committal court. Learned committal court. Full stop. This court, under its order dated 2/5/2024, call for the scan copies of the record as well as the case diary of the police station case, and also suspended the NBWA issued against the petitioner. The case diary, scan copies of the case diary. I have perused the case diary. The material so far collected, the case diary reveals that the FIR was lodged after
Almost 6 months, lordship.
after almost 6 months from the alleged date of incident. And it is also seen from the case record that the victim has refused to undergo the medical examination.
Blank case file earlier.
And the fact also remains that the complaint case was filed earlier by the earlier point on earlier point of time by the petitioner. Full stop. As the investigating officer has already completed the investigation and filed search sheet, full stop, this court is of the view that no meaningful purpose shall be achieved if the petitioner is put behind bar, in as much as the petitioner has specifically stated in this petition that he will he will participate in the trial and shall not abscond or will not interfere with any witnesses and not influence any witnesses. Considering the above, this court is of the view that petitioner have been able to make out a case for grant of an anticipatory bail. Accordingly, present petition stands allowed. Instead of police station, it will be all trial court.
Met with lordship. Idea ki lordship rejected page 20. Page 20. These are two matter date of occurrence 3/6/23 and 12/6 is the FIR. After 9 days. And allegation page, your lordship, page 10 is the FIR.
This is first time or second time?
No, this is the second, third time comes, officially, if you count third time, but second time would go, my.
Okay.
Would go, not CD, man, would go.
Is there is yes?
My lord, this is a search case, man.
Yes.
So,
Scan copies?
yes, scan copy has been received, my lord.
Actually,
because
I have annexed also.
it has been filed, my lord. It is for now appearance, my lord.
No, charge sheet was filed model 29/2/24. Dated.
Oh.
Page
29.
50, yes.
So for that,
Now your lordship will find page 33. I do not find, actually, in fact, my lord, the wife, husband committed suicide because of the wife, my lord. Because of the torture given by the wife. I am, my lord, that step brother, not a my lord. She is my adopted daughter of my
What is the
father.
FIR?
Yes, the FIR is page 10. Accused to number 1 already arrested. She is the wife of the deceased. Page 10, your lord. I am number 2.
Search sheet file under?
302/201. Okay.
302, my lord.
Yes.
It's 302.
302 and 201, my lord.
Yes. 33, just to have the 33 one. What is their got mind of what the ones kind of with under 161 anybody implicated minus? Nothing they have
Which
said.
page, which page?
Page 33 one. Bottom 4-5 lines my lord.
Be
In
there
course
for
of,
some time, come back. We'll
no,
give
in
you.
course of investigation over time. What is the basis
Earlier
of
it was AB.
Earlier, yes.
Earlier it was
Now
AB.
also AB, man.
now also AB my lord. Now also AB.
Page 33.
Yes, page 33, bottom your loss line 4-5 line in course of investigation. Your loss line. In course of investigation from the statement of the complainant as well as the available witnesses, it elicited that the deceased Islamuddin has purchased a plot of land.
Postmortem report.
Postmortem, your lordship will find on that page, my lord, page 33, plus below, lordship will find the, it is not a case of suicide, my lord. From below,
No, that is another suicide. Why?
below 3 lines, my lord.
Any person implicated me, my lord, from 161 statement.
In my opinion, that
Absolutely, you have been included.
cause of death is as per
Maybe that what will happen.
Nothing is there, my lord. No.
What will happen or not happen, we do not know in the
That
trial.
is correct.
That is a different issue. But fight was there. That is
Between husband and wife.
not
with
husband and
me.
wife. These three.
I am somebody else, my lord. I am not.
You are. What is your name?
No, no.
He is
My brother, my
Renumia. Yes.
yes,
both are brothers.
Renumia.
Renumia.
She is adopted daughter of my father.
I do not know.
But
Thing
who
is
is
that
separated,
basically, as per the CD, it relates to a property in whose name it should be registered.
I registered in the name of that my sister.
Ah.
This has made the dispute.
And the deceased was a drunkard and he used to beat his wife.
That's why wife
Beat-
also used to beat the husband.
Ha,
of the
so they
wife.
had
So
a
it is,
fight,
it is matrimonial dispute.
matrimonial dispute, but on the date, this is became much more aggressive. They started beating him and these two strangulated him and he died. Okay.
I don't mind of why-
That
why-
is the, what is the,
why
whether
not
this will be proved or not proved is a different issue.
I'm similar 161, anybody in 161, but they have stated my.
Yes, man.
I am what is the
there that-
basis of my lord coming to the finding that I am also involved.
Then the postmortem, that's why I have asked, what is the postmortem report says?
Right.
Postmortem report says strangulation.
Strangulation is there.
due to strangulation, my lord. Antemortem in nature.
Only 161
Just a
statement
minute.
also one
I
is
see.
there. The main two persons we have been known by one Najimuddin.
There is a
Abdul-
dispute between them that is admitted by.
No,
Who is
why-
the other accused in this case?
No, only two accused.
Who are the two accused? One
The
is,
wife already she
What
was
is-
arrested.
what was her name?
Shebu
Shebu.
Begum.
So, how far that will be an admissible, not admissible, that is a different issue, but we
Yeah.
are in 489.
Yeah.
She says all this before police.
She said,
She say before his police. Definitely will get this copy.
Yeah.
My husband started using abusive language in the name of my expired father, name of my brother. So my brother Renumia hits him and we try to control him. But after some time, he gets more aggressive and started beating both of us. And my brother and me put him in bed and press him in his neck. After that, he went out from press necks. In the morning, we heard that the suicide himself in a tree. Huh. But this,
so
these
she
things,
said that husband had put them in the.
no, both of them put him in
Strangulated.
next step. But she said we have not killed him. But that's part she said after. And the postmortem report says it is strangulation. So 439 is fine. We can grant you, but not 438.
I lift your
I
worship,
think
man.
it will not be an unreasonable act on our part. I think so.
I lift your worship.
Hard. Mr. Chaudhuri, HR Chaudhuri, Learned Senior Counsel, assisted by Mr. HR Chaudhuri. The present application is filed under section 438 of the Code of Criminal Procedure, granting pre-arrest this court during the period of investigation.
Page 20.
The petitioner earlier approached this court seeking pre-arrest bail, which was rejected by this court under its order dated
14/9/23.
page 21.
Page 21.
20, huh? Side level. Case 20, 49/2023.
Again,
Thereafter, the petitioner, thereafter the investigating authority has filed charge sheet and accordingly the petitioner has once again approached this court by filing the present application. This court already earlier called for the scanned copy of the case diary in connection with Karimganj PS case number 448/2023 along with record of the PRC case number 737 of 2024. Peruse the same, also including peruse the same, also peruse the statements of the witnesses as well as co-accused registered under section 161/162 of the CrPC. Full stop. Also peruse the post-mortem report. Considering the above, it is seen that sufficient incriminating materials are there against the petitioner. Accordingly, this court is of the view that petitioner has not been able to make out a case for grant of anticipatory bail. Accordingly, substance dismissed.
Obliged.
Yes, next case. Document of zero.
Please, your lordship. In this case, appeal was, delay was condoned, appeal was admitted. But unfortunately, the bail petitions, they were all convicted for 2 years, my lord, and fine would be 10,000. That has not disposed, my lord.
Aye.
171, my lord. So we pray that, my lord, it's, LCR has also come, my lord, meanwhile.
What is the period?
2 years fine. 323 is 5,000 fine, and 326 it is 2 years and 10,000 fine.
Aye. The present application is filed under section 389 of the Code of Criminal Procedure 1973 for suspension of the judgment and suspension of the sentence dated
23/12/19, my lord.
2019, now already over.
Oh, what means, my lord, they were not sent in jail, my lord. They were granted bail.
Previous bail.
Yes.
For how many days?
So, but immediately we applied, my lord, but this was remained undisposed. That is the problem.
You have not pressed it, I think.
They are not in the jail, my lord. They are on, still on.
Okay, application under.
We pray for remain to, they may be allowed to remain in previous bail, my lord.
23/12/2019. Passed by the learned session judge Karimganj in session case number 21 of 2010 under section 144, 148, 149/326, 323, whereby the petitioners were convicted and were sentenced to undergo imprisonment of 2 years under section 326/34 and to pay fine of rupees 5,000 under section 323/34. Full stop. The connected appeal has already been admitted. LCR has come?
Yes.
The LCR has also come. Full stop. The petitioner is are on previous bail.
Yes.
Considering the period of detention and the material available on record, the present IA stands allowed by allowing the petitioner to remain on previous bail. Full stop. Remain on previous bail. Full stop. Accordingly, IA stands disposed of. Main case of this appeal. This appeal was admitted on 24/2/2023. LCR has also been received the notice has duly been served and the respondent number 2 is being represented by
Yes, Tapada.
Tapada, Learned Counsel. Full stop. Accordingly, list this matter
For hearing
for
in due
hearing.
course.
Filing in due course, showing the names of the Learned Counsel for the respondent number 2 in the cause list.
Lordship, in the earlier occasion, the state respondent has paid for time for filing objection. Lordship, they have not yet
In this case, the office notice there, respondent number 2.
Steps.
We have taken lordship.
This is what is the offense here?
He is convicted under punishment section 6 of the POCSO Act, 10 years.
Okay. The Learned Counsel notice.
Regarding respondent number 2 expired, notice return is unserved.
Now what to do?
So
You'll have to have an instruction.
Yes.
From the concerned IO.
Yes.
Full stop. Office note dated 4/5/2024 reflects that the respondent number 2, the notice in respect of the respondent number 2 has been returned back with a report that the respondent number 2 has in the meantime expired. Expired along with the death certificate. Full stop. In that view of the matter, no further notice, notice need be issued to the respondent number 2. Okay, full stop. Now, what about the IA? IA,
Lordship.
what is the sentence
Lordship, sentence was
for?
10 years. Yes, Lordship.
And
You want to file objection?
because 10 years is so
Mr. Borthakur, Learned Additional Public Prosecutor, it ayat likhiba, huh? And the public prosecutor prays for and is granted 2 weeks time to file objection.
Much okay.
List accordingly.
হেৰি এটা দিবচোন কপি এটা দিবচোন নাই এপ্ৰিলটোৱে লাগিব মই নাই এপ্ৰিলটা
এটা আছে আৰু
যদি তোমাৰ হৈ যায় কথাখিনি দি দিলে
Yes, what is this?
Nice one.
This matter is this matter is the paper book has already been prepared. Accordingly, list this matter for hearing in its usual course, in its own turn. Yes, what is this?
My Lordship, I appeared on behalf of my senior, Mr. D.K. Boxi, for advocate for the petitioner. Service upon respondent number 3 is not complete.
Service upon respondent number 3. Who is respondent number 3?
Vishal Mandal.
Director.
1 and 2, Mr.
Yes,
You take fresh steps.
First,
Okay.
matter may be fixed
Yes.
first week of June.
We'll fixing after 4 weeks. Learned Counsel for the petitioner prays that she may be granted 5 days time to take fresh steps upon. You can't appear, Mr. Deuri, for 3.
I have no instructions. I will take instructions.
You take instruction in the meantime.
All the respondents have the same address.
Take the fresh key. Learned Counsel for the petitioner prays for 5 days time. No, that's Learned Counsel for the petitioner prays that she may be allowed to take fresh steps upon respondent number 3. First, a prayer is allowed. Such steps be taken within 5 days from today. Upon respondent number 3, notice is made returnable on give a date after 4 weeks. (25th of June).
Okay, my lord. Sir.
Yes.
My lord, we have taken a step, my lord. 2029/1/2024, my lord, we take a step, my lord. But as per office note, my lord, 9/5/2024, my lord, neither ID card nor the answered notice, my lord, returned. My lord, service report may be awarded at this stage, my lord. Service report may be awarded, my lord.
You take three steps.
Yes, sir. Yes, ma'am.
Okay, okay. We'll await for service report. Await service report in service report and list this matter after 2 weeks.
Interim order is there, that will be continued.
Interim order pass earlier shall continue till the next date of listing. Give a date. List this matter on 14th of June.
14th of June. Obliged.
Please, your lordship.
Yes.
It was a criminal revision petition against concurrent finding of guilt. On the last date, my lord was pleased to issue notice. The service report is awaited, my lord. And in the IA, my lord was pleased to direct us to deposit 20% of the compensation amount. My lord, we require one more month's time, my lord.
I Likhiva, Mr. Nawaz, learned counsel for the applicant, prays that the applicant may be granted
1 month's time, my lord.
1 month's further time to deposit the 20% deposit the amount in terms of this court's earlier order dated 23/4/2024. Prayer is allowed. List after 4 weeks.
I'm deeply obliged.
Await service report in respect of
Respondent number, sole respondent, my lord.
in respect of the sole respondent.
Deeply obliged.
Yes, Ahmed.
File one application for suspension of sentence and grant of bail. Lordship, and say last order, your lordship, page 52.
Page
52.
Of the
IA.
IA.
IA number 85 of 23. This was rejected on 26/9/2022. And he is as on today, lordship, he is in custody for 2 years, 7 months. And my submission, your lordship, is that
Okay, let us hear these matters. LCR is come. Okay.
Yes.
Next Thursday.
can it be on Wednesday?
Huh?
Thursday and Friday, I have some person.
Okay, give a date.
Wednesday,
This Wednesday, no, then we'll go to next week. Okay.
next Tuesday.
Next Tuesday.
On 4th.
4th of June.
Okay.
List this matter for Mr. Ahmed. That evidence will be it's readable. Readable. Okay, then no paperwork is required. List this matter for hearing main case to click here on 4th of June 2024. In the event matter could not be taken up for final hearing, the IA shall be considered. This court may consider the IA.
Lordship, for questioning of proceeding pending before the judicial magistrate under section 498A, my lord. Here in this case, my lord, the petitioner before your lordship
What about the notice to the other side?
filed an additional affidavit, my lord. Notice was served upon the mother of the informant, my lord. And she has put her signature there. She received.
That will not do in a criminal petition.
I may be allowed to say.
The learned counsel for Dusty is learned counsel for the petitioner is permitted to take fresh steps for service of notice upon respondent number 2
52 আছে
by both ways, comma, by both ways, comma,
49
an idea by registered post as well as through usual process. Such step be taken within a period of 5 days from today. 5 days to list this matter after 4 weeks. Till then, interim order pass earlier shall continue. You will have none appears for a petitioner on call list after 2 weeks.
May I please, Your Lordship?
Yes.
Notice was issued to the,
Anything, Mr. Bothakor?
My lord,
actually, this was consensus, my lord. They have it admitted in the 164 statement.
Police station, Dibrugarh Sadar
Dibrugarh.
Police, registered to do the needful accordingly. Any note? Office note?
Steps were taken, my lord, as directed by Your Lordship, my lord. My lord. 376.
This is offense under
376, man. And they made 470, man. Our statement, if Your
this is
Lordship,
squashment.
the charge again is framing of charge, man. So then if Your Lordship take up her statement, my lord, 164 statement.
No, that I recall is that because we thought that this she should be here.
And he has categorically stated that it was a consensual sex. Page 19, man. NHR 2, man. Number of occasions, my lord. Then she became pregnant. And she took rupees more than 11 lakhs from me, my lord, for settlement of the matter also.
Where is the order of cognizance?
For a pending charge, you will also find my
Order
lord.
of premises?
The order rated is 46 pages, my lord. Court, my lord, what is the pen, my court? And second page 48, my lord. On the face of the approach second para, my lord. I perused the CR and CD carefully for the purpose of considering charge. I have considered the statement of victim record on 160. Decision effort to learn and concept also carefully gone into. As we know, at the time of framing charge, probative value or material on record cannot be gone into. But before framing charge, court must apply mind on materials on record and must be satisfied that commission of offense of the accused as possible. Then he comes after, then taken by learned counsel.
Now tell me, it will, if we allow this petition in absence of the informant, that is any stay?
I pray for stay, my lord, presently, my lord.
Okay, heard. We'll state heard Mr. Kotoki, learned counsel for the petitioner. Also heard Mr. Bothakur, learned additional public prosecutor. The present application is filed under section 482 of the Code of Criminal Procedure 1973 by the petitioner, namely Swenso Silo, assailing an order dated 8/2/2024 passed by the learned additional session judge, Golaghat, in sessions case number 05/2023 within bracket T-Roman 2, whereby the charges under section 376 within bracket 1/417 of the Indian Penal Code were framed against the present petitioner. Full stop. This court, while issuing a notice of motion on 22/03/2024, also observed that the interim prayer shall be considered after not necessary. Full stop. The affair reveals that as per the affair, dated 24/5/2022, on the basis of which Bokakhat PS case number 68/2022 was registered. It reveals that the petitioner and the victim was having a love relationship, and the petitioner promised to marry her. It is also alleged that the petitioner, the informant also stayed with the petitioner in a hotel, and she had a physical relation with the petitioner. Okay. On the basis of that police station case, the statement of the victim was also registered under section 164 CrPC, which goes to show that the petitioner and the victim had a consensual sex. And she became pregnant. Full stop. Where is that statement?
Get a money, my lord.
Uh-huh.
That in the FIR itself, my lord.
Uh-huh.
The page 15, my lord. NEFT 10 lakhs was deposited in an account. On below, my lord. They made an agreement, took my signature, and I signed the agreement. By taking, they took some of the documents, bank account number, send me rupees 10 lakhs through NEFT.
Where is that agreement? Somewhere I have seen it.
Agreement is that is.
Huh?
That is page 25, Annexure 3, my lord.
Page 20, Annexure page 25.
25, page Annexure 3.
Okay. The material also revealed that the petitioner and the informant entered into an agreement
Before lodging of the affair.
Entered into an agreement prior to lodging of the affair that first party is
First party is the petitioner.
The petitioner shall pay
11 lakhs.
come on. Says the agreement also reveals that the dispute between the parties has amicably been settled with a condition that the petitioner shall pay an amount of rupees 11 lakhs to the respondent as full and final settlement as regards compensation to the unborn child. And accordingly, an amount of rupees 11 lakh was transferred to the account of the informant. Full stop. From the material, it is also seen that informant is a measure. Full stop. Considering the matter in entirety till the service is returned, it is provided that the further proceeding of
Session case number 5.
Session case number
5/23.
5/2023 pending for trial before the learned additional session judge Bokakhat. Golaghat shall remain suspended. They are advanced. They have decided to part apart and they have taken care of the children also.
Only while during hearing, I will have
Now-
to look into it regarding
Yes, yes,
417.
yes, that will be there
Yes.
for at the time of hearing. That's why
Yes.
we have not gone further.
Yes,
Let there be interim order. If she is interested, she will come.
yes.
Yes, next.
May please the lordship. My dear, we are agreed by rejection of our Jimma of cows matter.
Jimma
Cow matter.
Item number?
67 supplementary matter. 67.
This is.
They
Where
have
is your
filed-
application for Jimma?
In my application, I have not recorded, but it is there in the record matter.
No, this is not a case for quashing of the FIR.
Quashing of FIR.
Not FIR, matter, not FIR. Only matter that Jimma pair was rejected. So we have come for quashing and paying matter that Jimma be given to us. Matter. Not FIR.
Oh, yes.
Not FIR. Matter that
So you want a license of machine gun so that you can grant you a rifle.
Exactly not.
Yes. Otherwise, my lord, prima facie, my lord, offences are attracted.
Jimma of what?
Cows matter.
Cows. Cows
Matter
can be
these
enough.
cows were kept.
What is the ground for rejection?
Page 21, it's the first rejection, it starts at page 21, my lord. And operating portion lordship will find at page 22. The last paragraph, my lord, it starts from. May I read, my lord? The offense in this case was registered.
Prefer an appeal. This is an order passed under 11.5.
11.5, also preferred.
Then 11.5 is section 12 will there will be an appeal.
Appeal also filed, my lord, page 24. That was upheld, my lord, because of the bar created by section 11.5, my lord. That was also upheld. 11, it is.
File press application under 451 or 457.
That is why, my lord, we are before this court, my lord, that
What is your-
11.5.
Why should we exercise our power at 450? Is it our power?
Now, 11.5 is not an absolute bar where it cannot be given, my lord. That has already been, my lord, discussed in few of the cases which was dealt with by our High Court, my lord. I just please follow this court for your.
We have already dealt and we have said that 11.5 is a stage relatable to 11.3 and 11.4. Okay. And when 11.3 and 4 relatable to 11.5, then an appeal lies. Okay. But however, you are at liberty to approach the trial court
Yes.
in terms of chapter 34. And in chapter 34, this consideration will not come. Because section 11 deals with search, seizure and detention.
Yes.
Under subsection 3 and section 4, it is the duty to immediately at the earliest report to the magistrate. And at this stage, the cattle is to be kept in shelter because there is no way out. Cattle cannot be produced in the court.
Yes.
So therefore, legislature has said that except cattle, you can give possession even under 11.5, but no cattle. But that will not bar the magistrate to deal with the power under 34.
Yes.
Chapter 34.
To apply the bar of section 11.5, what I have found from this judgment, that there should be a prima facie satisfaction by the magistrate, then offense has been created under the Cattle Preservation Act. If that is not there, that bar will not come. And
Yes.
so, that Jimma can be given.
When, how much cattle?
13 numbers.
13 numbers of cattle recovered from who? What?
Me and this petitioner along with one another, my lord, kept this cattle at the house of one Abdul Motin because of the flood situation, my lord. And from their house, my lord, that has been recovered, my lord.
You don't have any receipt, nothing. So you have done transportation. These are allegations. Prima facie case is there. We cannot say that, so therefore we'll have to see the no prima facie case is made out, then whole proceeding will go.
My whole proceeding I have not challenged, I have just.
No, you cannot have both. You'll have to say no prima facie case means all case, because there is a specific exception to the so far relating to cattle.
11.5.
You have other options. Still, you can file an application under 451 or 457, as the case may be. Because section 11 relates to a stage of production under subsection 3 and 4. That's why so much of restriction. Police has been given, or even a doctor is given power to seize and detain. With a condition, it is kind of a situation related to 102 CrPC. Section 102 CrPC and Chapter 35 are two different stages.
Yes.
That is at the stage of production of.
So at the time of production, court says we will not give. We are not satisfied. Then you preferred an appeal. Appeal dismissed. Why should we interfere in a revisional stage? Withdraw it, and we are not here to give advice what to be done.
Withdraw, give them another chance, my lord. We'll go to the lordship's judgment, my lord.
Go through the judgment.
And I'll make proper submission, my lord.
Yes. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after a week.
Yes, sir.
That will be uploaded today only.
Yes.
Because of these vacations and I was traveling, no, I could not have. Yes, what is this?
My lord,
Bail.
no, my lord, on
What to be done today
lordship, I fix it.
for hearing?
Yes, my
When? You are inside or outside?
lordship, the matter pertains to the order passed by the executive magistrate in 146 proceeding, my lord. That is a matter so far that has been challenged here.
Okay. Also wrongly given. Okay, that is a difference.
So last time also that came.
Who is for the other side?
Okay, Lordship, can you see the order dated 22/11/2024 passed by your Lordship?
The last order, last time it was listed before the division bench.
Division bench.
Wrongly.
Wrongly. Now what to be done today?
Your Lordship, can you see the order dated 22/11/2024 in IA? IA.
Who is the IA?
IA 409.
IA for?
For vacating the interim order.
What is the issue? Tell us first.
Issue, Your Lordship, that order, this is all the things. Your Lordship, pass an order. 22/11/2024. Your Lordship, pass an order that took adjournment. Adjournment has been granted on conditions because already the matter has been decided by the civil court. And on the basis of a civil court order, they are not fallible. 145% has been dropped. They again,
At present, the issue has come to the revenue
You are
board.
for petitioner or respondent?
I am respondent here.
I am for the petition.
He is the petitioner.
In the main petition.
Main petition. So there is a 145 proceeding. Your Lordship, can you see that interim order is my lord page.
Page 22, my lord. The criminal petition. By this order, my lord, earlier attachment order was.
Order
was
dated
with-
4/11/2022.
Was?
The earlier attachment order was withdrawn by this order. So that was challenged before this court, before this honorable court, my lord.
Proceeding was dropped, my lord. Because there is a title suit, the matter has been already decided by the civil court.
It has come to the, now the.
Kindly see the order dated. More right.
Order dated
22/11/2024. No, 23, my lord.
22/11/2023. Suit, who filed the suit?
They filed a suit.
Then what will be decided in the case?
Lordship of,
Tell us, be fair, be fair.
yes.
Don't waste time.
Fairly, I'm just,
Ah.
the suit was dismissed. The suit was dismissed, but I may take your lordship to page 47.
Page?
47 of that I filed by them. Page 47. Last, last para, your lordship.
Suit is also dismissed.
That was dismissed. But lordship may peruse this. Para 47, last para. Page 47, your lordship. Got it? The last para. Heard the learned counsel for the parties and peruse the record carefully. I find that the defendant number 1, their father, admitted that the mutation of the suit land was in the name of the plaintiff. The defendant number 1 also stated that in 6.5 acres of the suit land, the mutation was done in the name of original defendant number 2, but he could not show any document to this effect. He also admitted that the land was converted to the periodic patta by paying premium in the name of the plaintiff. The plea taken by the defendant was that the suit land was a joint property land and the suit land falls in the ahera of defendant number 1 and 2 through separation by family arrangement. But the defendant could not prove the same by adducing any evidence. No family arrangement was shown, nor any independent witness was examined for proving the same. Hence, as the defendant admitted that the mutation was in the name of plaintiff and the premium was also paid in the name of the plaintiff. Therefore, the title in the name of the is the name of the plaintiff. But as the issue number 1 and 4 has been decided in negative, and issue number 6 is decided in affirmative, and that was the observation of the court. So far, they have claimed the petition.
They are the, according to this, they are the owner.
According to them.
According to this order also. This.
This is for-
Therefore, the title is the name of the plaintiff. Hence, the defendants admitted that the mutation was in the name of plaintiff and the premium was also paid in the name of the plaintiff. Therefore, the title is in the name of plaintiff. But as what was the issue number 1 and 4?
Issue number 1 and 4, your lordship will find.
Matlab page 43.
This 40.
Whether there is any cause of action
Oh,
for
yeah,
the
yes,
claim.
madam.
And 6 is
Presence.
whether this suit is barred by limitation.
So these are the 2 things. And apart from that, my lord, it was also admitted by them that land was in the
Now,
possession.
see, you are not in possession is determined by a
No.
civil suit.
No, my lord, that was admitted by them. So far, the
Mr. Counsel, what was the issue number 4? Nobody comes.
whether
here.
plaintiff is plaintiff is in possession of other said property.
Okay,
Yeah.
that said that you are not in possession. What more is required?
So far, my lord,
Just tell us. A 148 proceeding is as regards determination of the possession.
yes, my
Who is in possession? A competent civil court has decided the issue that you are not in possession. You are the plaintiff of the suit,
yes, my lord.
is not it? This was any appeal preferred against this? No appeal
No
preferred.
appeal.
Matter ends there.
And so far, the matter has already that has been challenged before the revenue board also by way of another. May I
That
take your
we do not know.
may I take your lordship to this additional affidavit filed by me?
No, nothing.
Because
Hard.
the applicants have been their applicants have applied for
No,
their
the question I have asked you, answer it.
yes, my lord.
Suit was filed by you for declaration of right title and for position and confirmation of position. Confirmation of position. One issue was framed that who is whether plaintiff is in the position because they denied that you are not in position. And that issue has been negated by a competent civil court saying that plaintiffs are not in position. Can thereafter a magistrate court, executive magistrates court under section 145 determine possession?
Because that was according to them. that
Answer the
is-
question.
Yes,
Is it
my lord.
permissible
But
or not? Answer that question first. Or you want to say that as executive magistrate can sit over and determine the possession after a decree is passed?
Like that, my lord. So far, their mutation has been also cancelled.
That we
And
do not
that,
know.
that matter has come to the revenue board now.
Now,
That
if
matter
their
is going-
mutation is cancelled, it is pending before the revenue. Where is the jurisdiction of the magistrate under 145, 146?
No, it is in the other heading. They applied for the mutation. That has been cancelled because they are not in possession of the land.
Heard the learned counsel for the petitioner. The present revision petition is filed against an order dated 4/11/2022 passed by the learned executive magistrate Kamrup within bracket Amingao. Full stop.
In case number 52/22, my lord.
In case number, where is the order?
20, Lord,
Yes,
you will
I
find
think
page
my-
22.
Huh?
Page 22,
Page
page 22.
22. Of my criminal petition.
In order, in case number 52
M/.
2022.
Yes, my lord.
The petitioners. The aforesaid case was taken. The aforesaid case was taken up on the strength of a report received from Circle Officer Somoria Revenue Circle dated 21/2/2022 in connection with Boko PS Station case number 82/2022 and 83/2022. As per the aforesaid report, there were apprehension of breach of trust between the parties as regards possession of a plot of land measuring 9 bigha 02 katha 12 lesas covered by Dock number 937 of KP Patta number 212. Full stop. Accordingly, by an order dated 11/3/2022, an order of attachment of the land was passed. Both the respondent herein preferred revision petition against such order. What happened to that revision?
Those are withdrawn.
Huh?
Those are withdrawn.
However, those revision petitions were subsequently withdrawn.
And they
cases,
prefer to revision.
Two revision withdrawn.
Withdrawn, but there is well, there are some misunderstanding among the lawyer. The lawyer has been questioned. Warning has been given to the lawyer.
Subsequently, on the basis of Latmanda's report dated 5/3/2023, subsequently, by the impugn order dated 4/11/2022, the proceeding was dropped Proceeding was closed, holding that the possession over the land, the second party / the present respondent are having possession over the disputed land. Full stop. Such determination was made on the basis of a report of the Departmental dated 5/3/2022 and on the basis of the judgment and decree of the Learned Civil Judge Junior Division number 3 dated 10/9/2004 passed in title suit number 23/2021 filed by the predecessor in interest of the present petitioner / petitioner in the proceeding under section 145/146 CrPC. Is it correct?
Yes.
Yes, full stop. The said order is under challenge in this present petition. The decree of title suit number, where is the judgment and decree? Title suit number.
There's
It
40, my lord.
Page 20.
40 is the title. Mine is case. That judgment.
Title suit number 23 of 2001.
Title suit number. Title suit number
23 of 2001.
23 of 2001 was preferred. The title suit number 23 of 2001 was preferred by the predecessor in interest of the present petitioner. Full stop. And of declaring right title interest and confirmation of possession over the disputed plot of land. One issue, i.e., whether plaintiff is in possession over the suit property was framed. Full stop. The learned trial court answered the aforesaid issue against the plaintiff, that is the predecessor in interest of the present petitioner. That being the position, the decision of the learned magistrate cannot be faulted with, inasmuch as a judicial magistrate cannot redetermine an issue of possession when when decision in this regard involving the same property has already been taken by a competent civil court and a decree has already been passed. In view of the aforesaid, this court finds no merit in the present application. Accordingly, present revision petition. Accordingly, the criminal revision petition stands dismissed. Full stop. In view of the order passed in the connected criminal revision petition, IA stands closed.
Hello.
Yes, where is the money?
My lord, item note, just now I have got the instruction, my lord, that by Monday, my lord, I will get the report from the, my lord.
Money, when will you return the money? Tell us that.
We have sought for an instruction that day itself 120 signal. Now office is saying that they are sending the case diary.
Intimated Mr. Chaudhary that you are saying.
Thus they are saying that they are sending the case diary not yet received. We don't know.
Monday. On Monday we'll pass the note. We want to see what is the offense that he has committed. What is that allegation?
I have explained the source.
No, I understand. Let them have their satisfaction. Money will get back. Wait for a weekend.
Yes.
Okay, Mr. Paras, Borthakur Learned Council for the Learned Additional Public Research submits that he has instruction from the IO that by Monday, the case diary of the case shall invariably be produced before this court.
Let it on Tuesday, let them have actually one more day.
Tuesday, by Monday. Accordingly, list this matter on Tuesday. Not possible. Inside or outside?
Inside, that's why.
Let us take a
326.
chance. What is the issue?
Convicted under section 326.
Well, today so many methods in this before this ban. Under section
326 euros. For 10 years euros.
326 for 10 years. Where is the FIR?
Your lordship, FIR, your lordship is exhibit, your lordship, one, your lordship.
Anything?
But the respondent side is not present, their names are shown.
We cannot help it. LCR from LCR, Mr. Bhattakur.
Exhibit 1.
Let us just understand, not possible to decide today until let's just have some understanding since file is here. Page,
Paper book is not there since.
anything, have you prepared anything?
Lordship, otherwise your lordship, the FIR, your lordship says, may I,
Anything in with the IA? Nothing.
no, your lordship. Your lordship, it was said that IA will not be considered, the matter entire matter.
10 years, 326.
326.
Now, who are the injured witnesses?
No, there are one in-person injured, your lordship, he later on died, your lordship, not after 4 or 5 months as per the evidence of the expert. Then this has nothing to do with the injury, your
So
lordship.
there is no 302 added.
302 was added, your lordship, but ultimately conviction is under 326. Initially, search sheet was
326 conviction on the basis of who's any eyewitness?
There are 3 eyewitnesses, your lordship. 2 eyewitnesses say that I stabbed him, and 1 eyewitness says that there was no marpit had taken place. That's what your lordship, the eyewitness said. And
what was the reason of marpit?
Marpit, the land dispute, your lordship. There was a land dispute. My case would be, your lordship, since this is your lordship, not a case of 326. At best, it is a case of 335. And even if it is 326, 10 years is too harsh, your lordship.
Okay, what is the medical report says?
Medical report says 1 injury, but there are 3.
1 injury by?
By your lordship, blunt weapon.
Weapon. Any stitch, nothing. Where is the a part of the body?
Belly. None, your lordship.
Any weapon seized?
No weapon. No weapon.
Okay, give a date, we'll decide it.